Okay, so I think that we can start. As I know, you can hear me. I mean, those who are online, because those who are here at the Jagiellonian University, for sure, you can hear me and you can see me. So on behalf of myself and my colleague, Krystyna Trichlip from the Jarosław Mudry National Law University in Kharkov, I'm delighted to welcome you to this international conference organized as part of the research project Rule of Law and Independent Judiciary, Key Challenges for Ukraine and Poland in the context of European Union integration. We are deeply grateful for your presence here at the Jagiellonian University in Krakow, but also online as the conference is organized in a hybrid format. I extend a warm welcome to our distinguished speakers from Ukraine, the United States, Germany, and Poland, as well as to the moderators of the panels for today and also for tomorrow. Your acceptance of our invitation and participation in the discussion is greatly appreciated. I would also like to especially welcome our students engaged in the project from both the Jagiellonian University, but also from the Jarosław Mudry National Law University in Kharkiv. We eagerly anticipate your presentation tomorrow, and thank you very much for being with us today. Today's conference, entitled Judicial Independence and the Rule of Law, Overcoming Challenges for Ukraine and Poland in the EU Integration, is the latest in a series of academic events we have been organizing together with Krystyna since October 2023 under this project. Our aim was to foster scientific discussion around the critical issues of judicial independence and the rule of law in Poland and Ukraine, and also highlighting the urgent need for comprehensive reforms of national institutions such as the Supreme Court, the Constitutional Tribunal, but also the but also the National Judicial Council. These reforms are essential for both countries to advance towards European Union integration. Additionally, we must still remember Ukraine's ongoing struggle against Russian aggression, which poses a significant challenge, not only for this country, but also for the European Union's commitment to its core values. We hope that Ukraine will emerge from the war stronger, free, and independent, and that our project will contribute to rebuilding the country's democratic institutional framework. And this project has been made possible by the generous funding from the Foundation for Polish Science. We are honored and grateful for the support of the foundation and under the special program for Ukraine and for the Foundation's confidence in our vision for the research within this project and the scientific discussion. Today we are pleased to welcome Ms. Sofia Azovtseva, the coordinator of the program within the Foundation, and I'm delighted to invite her to take the floor, share a few words about the program, and extend welcome on behalf of the Foundation for Polish Science. So the floor is yours.
Thank you. Ladies and gentlemen, there is a pleasure today to be in this conference, Judicial Independence and the Rule of Law, Overcoming Challenges for Ukraine and Poland in the EU Integration. I'd like to extend my gratitude to the organizers, Professor Monika Florczak-Wontor and Dr. Krystyna Trichlip, for the invitation. I also want to acknowledge that Professor Florczak-Wontor and Dr. Trichlip are winners of the third Polish-Ukrainian program for Ukraine funded by the Foundation for Polish Science. I hope their project will contribute to the development of judicial independence and the rule of law, which are crucial for both Ukraine and Poland. This is especially important for Ukraine right now, as it just began active negotiations to join the European Union last week. Judicial independence is clearly essential for creating fair and democratic societies. Moreover, this project is an excellent example of effective internationalization and expanding cooperation beyond Polish-Ukrainian relations, as evidenced by the participations from of the experts from the United States and Germany. Foundation for Polish Science continuously supports Polish-Ukrainian scientific cooperation and social science within the For Ukraine scheme. We are also still raising funds that would enable us to support more young researchers in Ukraine. The first call was announced this spring, and the applications are currently undergoing the expert review. We hope that future winners of the call will be as motivated and inspired as Professor Monika Florczak-Wontor and Dr. Kristina Trychlib. I wish you interesting discussions and fruitful work. Thank you.
Thank you very much. Thank you very much. And again, also, thank you for coming here from Warsaw to Krakow and for being with us. And so for today, we have two panels, and I would like to welcome the moderator of the first panel, Professor Natalie Fox-Wielok. She is an assistant professor at the chair in comparative constitutional law at the Jagiellonian University. And we'll have three distinguished speakers. I hope that the third one is online, because this is something that we didn't check. Alexandra, could you confirm that you are online with us? Yes, yes, okay. Yeah, so I would like to invite Professor James Moliterno and also Justice Konstantin Pilkov. Please, Natalie, take the floor. And we will have to sit in front of the computer at this moment, yeah, okay? Natalie, so you're here? Yes.
Hello, everybody. It's a very nice pleasure for me to be a chair today. We've got three speakers, as Monika said, and we've got 20 minutes for one speaker, and then I think 30 minutes for the discussion. It will be okay? Yeah. So we can start with the first speaker, is James Moliterno from the Vincent Bradford Professor of Law Emeritus at Washington and Lee University School of Law. And the topic of the presentation, it will be Faulty Foundations for Reform. The floor is yours,
Okay,
please.
thank you. Thank you very much.
Change, yeah, okay.
We could invite you to sit down here, okay? Just in a moment, because...
So while we are getting situated, let me just say how very happy I am to be here for this event. It's a beautiful city, of course. I have only been here one time in the past, and I actually see a few of the people who are on Zoom, a couple of friends, people I know from past events and past work. So thank you for being here. I very much appreciate it. We will share my presentation, I think, here in a moment. One thing I can do before we get my presentation up is just introduce myself just a little bit. So I have been on law faculties in the US for 42 years. You see, I have no hair. What's left is gray. I have been doing this work for a long, long time. I actually recently retired from my American university position after 42 years. I think it's enough. But for the last 20 years, little more than 20 years, I have been engaged in justice building projects, we might say, in mostly in Central and Eastern Europe. So I have worked in, I think, 10 countries of Central and Eastern Europe. I have also worked in China, Thailand, Indonesia, some Asian countries, but mostly I have worked in Central and Eastern Europe. What have I done here? I have worked either with lawyers or judges on their ethics and disciplinary institutions. So I have helped helped to build sometimes lawyer ethics courses for law faculties, but mostly disciplinary system, codes of ethics, things in that nature for judge groups and lawyer groups. Czech Republic, Slovakia, Ukraine, Georgia, Armenia, Serbia, Kosovo, some others. Never in Poland, except to come for a conference. So this is what I've been doing for quite some time. So while I will never be a local, I will always be an outsider. And I understand that 100%. I guess among Americans, I probably have a better understanding than most of the way systems work, the way the legal culture works in this part of the world. And as a result, I have been able to see firsthand efforts at judicial reform or lawyer ethics reform and things like that. And so my talk today isn't quite up yet, but it's called Faulty Foundations for Reform. It is a talk about the reality that we don't often look at what is the status quo in the country on a certain topic before we launch into some reform efforts. And in my judgment, this has meant, are we going to be able to put the...
Yeah, we will have to wait for
it. Okay.
Sorry.
And as a result, either there are times when perfectly good-hearted reforms, good efforts that would otherwise work quite well, either fail or do harm, because the foundation on which the reform needs to be built is lacking, is not there. And so I have seen, I'm going to start my presentation even though we're not quite have it up, it's okay. I have seen a lot of reform just for reform's sake. Like, we want to reform, we want to change, we want to do something, and we simply launch into it for some reasons that are not the best reasons. And so we do it without enough thought. How does this happen? Sometimes it happens because of the NGO, and I might be working for the NGO, the non-governmental organization that is managing the effort to reform from outside, or trying to. And they are trying to build the case for getting the next grant, right? They want to be able to show in their reports, we changed this, we changed this, we changed this, right? And so that is one of the motivations sometimes for reforms when they should be thought about more carefully, I think, in my judgment. Sometimes we are in an accession to EU or some structure like that, and from some outside authority, we feel like we have certain boxes we need to check off, right? We have done this, now we have done this, now we have done this. And that too often fails to consider what is the success possibility for that. And even parliaments, I have seen, local parliaments, sometimes are trying to say they are reform-minded and they make changes, but without the necessary consideration of what is underneath already, what is the status quo already. So there are many excellent reforms, at least in theory, and they are things that I'll tell you about in a moment. You'll recognize they've been done in many countries and with good intentions, right? With very good intentions, but sometimes, in my judgment, have been done at the wrong time, have been done when there isn't the readiness for it. So if they were introduced on proper foundations, they would enhance public trust in justice. They would create better justice for the citizens of the country that we're talking about. But when they are introduced on faulty foundations, the wrong foundations, they not only fail to improve the situation, they sometimes do great harm on their own. And I have seen this happen, unfortunately. In a way, what we are today and you have been, Monica and Christina, you are a kind of reform network, right? You are mixing people from at least 2 different countries who are talking about what has happened in Poland, what has happened in Ukraine, etc. But there are many other reform networks, I would call them, international reform networks. On the screen a moment ago was a colleague of mine from Georgia, and I assisted them in creating something called the International Network of Judicial Reformers. They're a great organization. They do online meetings almost every month, and they have about 100 members from maybe 15 or more countries. And there they are on Zoom, and they share ideas. It's a great thing, right? It's a wonderful thing to be able to do that. Discussions of reformers about different things that they have tried in their countries. But there is one pitfall that needs to be guarded against in those international reform networks, and that is sometimes I hear people say on the call, well, they say this worked well in X country, let's do it here, right? And again, my pitch for today is this idea, great, here we are. My pitch for today, let's get the slideshow going. Okay. You can read this now. Great. My pitch for today is that when we learn about something that worked well in Poland, should we do it in Ukraine? It worked well in Slovakia. Should we do it in Georgia, etc.? Right? When we do that, we have to stop and think, what is the current status quo in the country where we are going to propose this reform? Is it ready? Is it prepared in a way that that reform might work here also?
We have the presentation. We have the next one. The next one.
Sorry?
We'll change it.
Oh, you will change it. Okay. All right, great. So we are already on slide number 5. Okay, it's number 5 we are on. Yeah, okay. For every proposed reform, wherever it is happening, we have to think about what are the foundations that would make this reform successful. And then, are they here? Do they exist currently? And if not, is there something we can do to build them before we institute the reform, right? We also have to think about what are the consequences of this reform on a bad foundation, on a faulty foundation. What will happen as a result? And where will we be able to do this? Okay, we can go to the next slide. Thanks very much. I'm going to talk just about 3. There are many, 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 as you all know. I'm just going to talk about 3 very common, very popular, very good reforms that can help judiciaries if the proper foundations are there first, right? So I'm going to talk very briefly about life tenure for judges, about heavily vetting, right? Heavy vetting for existing judges for reappointment, not for new judges, but for reappointment. And third, the very common in Central and Eastern Europe, having judicial councils, very powerful judicial councils with majority judge members who are selected themselves by the judges. Okay, so I'm going to talk about those 3 just very briefly and talk about the foundations for them. Next slide. Yes, great. Okay. So what is the goal of giving life tenure to judges, right? Why do we do it? We do it so that we can enhance judicial independence. They are not going to be worried. They shouldn't be worried about pleasing the government, pleasing state actors of one kind or another to be reappointed, right? We want them to be able to even challenge what the state actors do and say. And if they have life tenure, they will be more independent. We believe this, and I believe it to be true, right? I believe it to be true. But what's the necessary foundation? The necessary foundation is that there must be an existing cadre of honest, good judges, or the creation of new judicial positions, which we can carefully populate with good, honest, not corrupt judges. And we have to have a reliable system for choosing new judges. And some, like in Ukraine, the changes in choosing judges recently, in my judgment, are wonderful. They are fantastic. So we have to have those things in place. If we give life tenure to a corrupt cadre of judges that already are in their positions, yes, we increase their independence. We also increase their lack of accountability. They're not accountable to anyone anymore. And we cement, right? It's like we've created the perfect foundation for continued corrupt systems if we give life tenure to judges who are already in a corrupt judicial system. So we need to think about what is the foundation before we do this. Often the US is cited as the example of life tenure, right? The US has life tenure for our federal judges, not our state court judges mostly, but our federal judges. Okay, we do. But when did the United States begin its life tenure for federal judges? It began it in 1789. Do you know how many federal judges there were in 1789? Anybody guess? Anybody? Zero. There were zero federal judges when we began this, when it's in our Constitution, in Article 3 of our Constitution, adopted in 1789. There weren't any yet. We couldn't create life tenure for corrupt judges. There weren't any judges. And we built at the same time, I say we as if I did it in 1789. I'm not that old. The United States built a system for selecting federal judges at that time that was designed and has worked reasonably well, with some mistakes for sure, but has worked reasonably well to have a balance over the centuries of liberal judges, of conservative judges, judges appointed by different political parties and presidents, confirmed by different members of the Senate, and so forth. So over time, it produced a nice balance, not always perfect, but a nice balance of liberal judges, conservative judges, different kinds of philosophies, and so forth. But there were no federal judges at the time who could be cemented into their positions forever. No, they were the new judges that would be chosen from that moment until this very moment today, right? But for example, I won't name it, in one post-Soviet republic where I have worked quite a lot, life tenure was introduced when the judges already had a quite effective, deeply corrupt system. And what has it accomplished? It has made them more independent, right? No one can touch them practically. And now it is even harder to get other reforms to make that system work better. So a good-hearted, well-intentioned reform planted on a faulty foundation, in this example, produced quite a lot of harm, Quick example. Second, well-meaning reform, and works well sometimes. Heavy vetting, I can say, of existing judges for reappointment. So we know that in the very early post-communist times, different countries engaged in different levels of what at that time at least was called lustration, right? Maybe judges who were high enough members of the Communist Party, or maybe judges who were identified as intelligence officers or intelligence sources for Communist Party. They were set aside, right? And different post-communist countries had different levels of lustration. Some wiped out everybody almost of the judges. Some, just a few, were taken away. But then life went on, right? Life went on from there. Okay. Today, some countries consider having a very close vetting, very close examination of judges who don't have life tenure when they are up for reappointment. If it is well designed, it can be a very useful tool, I can say. When it is well designed, it can be a very, very useful tool. The selection process, and I mentioned here both in Ukraine and Slovakia, I know that the selection processes for judges have been much improved in the last 5 years or so. The selection processes in Ukraine, I think, are now working quite well, in my judgment. Maybe you were selected through one of the new processes. Okay, so you know it was working well, right? But in Slovakia also, I've worked, and the selection process has become much more transparent. People can watch the interviews of judge candidates now. That didn't used to be the case. People know who are the people selecting the judges, and the people selecting the judges are selected more carefully now. So there are many improvements, and this kind of vetting can be very, very valuable. But what happens when it is possible, as it has been occasionally in post-communist countries, to reappoint all the judges effectively at once? I participated to some extent in that kind of activity in Kosovo. So in Kosovo, under UN and then under EU supervision, right, it became possible that all of the judges, all of the existing judges, would essentially have to apply for their own job, right? Apply for the job they had. So the potential was there to root out many corrupt judges. It was a great opportunity, a great opportunity. And I did some of the ethics training, some of the teaching of the existing judges as that process was happening. But I wasn't involved in the process itself, the reappointment process. A tragic mistake was made in that process. And it was a mistake that I think is too common. And I will say what it was now. In Kosovo, it was decided by the local authorities, and I say local meaning the EU supervisors, the UN supervisors of the country at that time. They decided that there would be an exam, an ethics examination like you students take in class, right? And it would be part of, not all, but an important part of the reappointment process. How would the existing judges do on the exam? Tragically, in my judgment, they hired a judge, a very nice judge, very good judge, from the US state of Minnesota to write the test. Well, of course, he studied their law on judges, their law on courts. Of course he did, right? But he wrote a test that was modeled exactly on the ethics test that we give American lawyers to become an American lawyer or judge. It was exactly like it. It was a multiple choice test based on scenarios, on hypothetical stories. So there would be a paragraph, big one, with a story about something happening to some judge in the court, maybe, and then 4 choices. Which is the best choice? In the American test, it is designed explicitly, created so that there is more than one correct answer of the 4. The student, the one marking the exam, taking the exam, is meant to pick the best answer, even from among 2 or 3 that are not bad, right? They are themselves correct. This is very challenging to do. But the Kosovar judges, the ones I worked with and dealt with at the time, they had never seen an exam like this in their whole lives. I mean, in all of school, that was just not the kind of exam they had ever been exposed to. So why give it to them? To me, it made no sense. There were great judges that I know, excellent judges that I know, I knew at the time in Kosovo who failed the test miserably, got very, very, very bad scores on the test, but I don't believe it was a sign that they lacked good judicial ethics. I think it was a sign that they didn't know how to take this kind of test. So if we get the chance to vet existing judges, to examine existing judges for their own positions, to even give them a test or something like that, right? If that's the choice that is made, the test, as all tests, I mean, even the ones you take in school right now, the ones I've given my students for 42 years, the test should match, right, the job they are applying for. There should be a connection, right, between the test and doing well at the job. That was not done in Kosovo. And the result was that many, many good judges were no longer judges, and many bad judges did just fine, even if by accident. Many bad, corrupt judges did just fine. So is it a bad thing to have heavy vetting, to consider the possibility of having a reevaluation of even all of the existing judges? It's not a bad thing. It can be a great thing. It can do wonderful reform for the justice system in a country. But the measures of examination, the measures of how we evaluate the existing judges have to match the culture, and they have to match the job that they are applying for. Third one, judicial councils are now, I think, in almost all post-communist countries that have either entered the EU or wish to enter the EU, except one. Does anyone know which country I mean that does not have a judicial council? Is my time up? Okay, sorry. No, it's Czech Republic. Does not have the judicial council that I know in Ukraine you have now. I know in Poland you have, in Slovakia they have, et cetera, et cetera. In Georgia they have, because they want to move closer. And so there are some parts of Europe where they exist already, but not many actually, except for the countries that either have entered in the 2000s or wish to enter. What is the goal? Create more judicial independence where there was none, quite frankly, at the communist time. And that's a good goal, but it can be sought too vigorously and without an examination of the foundations. What do I mean by that? I mean that if there are existing corrupt elements within the judiciary, and if they are well organized, they will only be strengthened by this judicial council that is selected by the judges and controlled by the judges. It will only reinforce, for example, I have worked in countries where court presidents have a lot of power and use their power in corrupt ways. I have worked with people who work in such courts and are afraid of their court president, for example, because of that. Well, the Judicial Council has to be built in a way that has good counterbalances of accountability. So it is only in the last year or two, maybe three, that the Venice Commission has now begun to talk more and more and more about accountability, to balance the kind of judicial independence that we're creating. Judicial independence is wonderful. Don't get me wrong. I'm not criticizing judicial independence at all, but it needs to have the counterbalance of accountability. It can't just protect corrupt practices within judiciaries. My time is up. I'm trying to just finish up. Okay, that's good. So what do we need to do when we are going to reform? We need to carefully examine the foundations, the status quo that exists in a country, and we need to think hard about what will happen next year, the next year, the next year, in terms of what will that reform actually produce, good or bad, given the foundations that it's built on. Thank you, and I'm sorry I kind of ran over.
Thank you, Professor, for a very interesting speech. And please let me introduce our next speaker. It will be Konstantin Pilko. He's a PhD in law justice of the Supreme Court of Ukraine and Grand Chamber. The title of the speech is The Judge's Speech, Freedom and the Duty of the Judge to Speak Out in Order to Safeguard the Rule of Law and Judicial Independence. So you've got 20 minutes.
They are starting now, although that
Please maybe sit here, okay? Because there's things. I can go
as a judge, I heavily, I really appreciate if I can preside over my case and manage my representation. This is a work, but if you. Okay, so thank you for this opportunity to be here. Thank you for, and now I'm pointing at the sign of the Jagiellonian University. Thank you for making my special relations with this university official now. I'm truly touched with that. And thank you for the opportunity to speak to you on the topic of whether actually a judge can talk freely, openly, and publicly on the matters of judicial independence, whether I can not approvingly on what my colleague, the earlier speaker, told about critique of corrupt practices in the judiciary, or whether I should refrain from that. There are three issues that might serve as a spoiler for what I'm going to tell to you. First of all, the topic of the speech. Second, the common sense. For many of you, it is obvious that the judge may speak about those issues. And the third one, the third spoiler is that actually I will talk about it. But still, for many Ukrainian judges, it is not that self-evident. And this is hence the name of the topic, the judge's speech, as a reference to a known movie, King's Speech, one of my where the main character didn't believe that he has voice. So many of my colleagues have this feeling that they have a voice even in the matters that are related to their independence and independence of the judiciary as a whole. They refer that matter to the president of the court, to the special institutions like council, but not allow themselves to express any assessment of the state of the independence. So where did that come from, at least partly? And what shall we do with that? Or shall we leave that alone? Here was that some of these words were moving. Actually, there is a reference to Bangalore principle of judicial conduct, our alpha and omega of what is ethical in judicial conduct and what is not. And there is a rule, or rather a comment on one of the ethical rules, is that a judge should speak only through his or her reasons for judgments. And although this is the rule that is dealing with, that is related to the judge dealing with cases being decided, so the case before the judge, many of my colleagues and many of my colleagues in other countries understand it that way, that the judge shall in any speak through their judgments almost in any controversial issue, almost in any issue at all. I wonder whether my colleagues speak privately to their loved ones at home also through their judgments only. So although this is a specific restrictions that is related to not being chatted too much about the case that is before the judge, so that not to harm the positions of the opportunity of the parties to present their case, and not to harm the future decision of that judge. Many of my colleagues understand this is as a clear rule that shall govern their public activity. There are a number of other guides, guidelines, comments, codes of judicial ethics, where there are words like abstain, preserve the dignity, refrain from any political debate, refrain from any hot topic, apply the principle of moderation to what you are going to speak, that actually form this psychology of and form this attitude that the best strategy for a judge is to abstain from any debate, from any public speaking at all. Unless it is a scientific discussion, it is a lecture. Oh, I really hope that this counts as one. Certainly, I'm in the university, so from the prospect of the German standard of moderation, I'm now in a safe place, unless I overstep professional boundaries and go into heavy criticism of some personalities or some events. So this is what form this environment of silence in the judiciary. It's not that we have nothing to talk to you. It's the constant reminder about the boundaries that form this strategy. But how could this happen in that environment? This is the pictures from Guardian and Times of I may say most recent events in January 2020, when many of my colleagues from many European states came to Poland to support their colleagues in the March of 1,000 Robes. So this is a completely an opposite of what I just told you about the moderation, refrain, and restrictions of taking part in matters that are potentially have this connotation of being part of a political issue. Actually, what is not a political issue? Any hot topic related to the rule of law, fundamental rights, is has the border of a razor blade with the politics. So, shall a judge abstain from any participation in discussion about those things? I might say that during recent years, the situation changed dramatically, and your country, the events that took place here, made a significant contribution to that. Certainly, the most significant progress that formed this unity in approaches among, first of all, European states came from the jurisprudence of the European Court of Human Rights and other institutions who provide the guidelines like Consultative Council of European Judges, European Network of the Council for Judiciary, and some others. First, in the I might say, old case of Kudeshkina versus Russia in European Court of Human Rights, where the judge, Olga Kudeshkina, was dismissed following her heavy critique on the radio of Moscow of the situation in the Moscow City Court, where she stated that according to her experience of working in the Moscow City Court, there is no independence in that court, and that the judges are under constant pressure. So she was dismissed in a qualification procedure. And the European Court of Human Rights addressed this issue of critique of the state of independence by an individual judge. Next, there was an issue of public criticism by the head of the Supreme Court, by the Chief Justice of Hungary, who was also the president of the Council for the Judiciary of that country. So I made something wrong. I really hope that at least you can hear my voice.
Yeah.
Yes,
Okay,
we
thank
can.
you. Where the European Court of Human Rights specifically pointed that the position of the applicant, Mr. Baca, who was the president of the Supreme Court, imposed on him this duty of addressing these issues of independence of the judiciary and participate in that debate, although some of his remarks may be questionable, debatable, etc. And there was also the judgment of the Inter-American Court of Human Rights upon the application of 3 judges who participated in the public protest against the coup d'etat, as they assessed that, although the official assessment of that coup d'etat was the constitutional succession of power. Those 3 judges, had their subjective view. They participated in the association, and they expressed publicly their view that the democracy in the Honduras need to be restored. That was completely contrary to the official line of the public institutions and public institutions in the judiciary. And finally, there is the case of which all of you, I believe, my colleagues from Poland are very well familiar with, the case of Jurek versus Poland, where the European Court of Human Rights finally made a statement, made an opinion that this right of free speech of a judge might transform into a duty to publicly speak out if the fundamental values are under threat. And moreover, in that case, although Mr. Jurek was a judge who occupied at the time the position of the spokesperson at the National Council for the Judiciary, the European Court of Human Rights reiterated that those conclusions, that opinion is relevant also to any judge. So it is, in view of the European Court of Human Rights, the public duty, the ethical and might be a legal duty of any judge to make necessary steps in order to defend the independence of the judiciary. So now let's see in chronological order of those dramatic changes in understanding, first of all, by the organization that are dealing with unification of approaches among the judiciary of different countries. First of all, Consultative Council of the European Judges and the European Network of Councils for Judiciary. You might see that in the early 2000s, the yes, thank you. The wordings were modest and rather restrictive. Yes, judges should be allowed to participate in certain debates. This is actually in line. This is in line with all those restrictions of the freedom of speech that is embedded in national codes of conduct, sometimes in national legislation. In 2007, we see that in the comments to the Bangalore Principles, there is another restrictions that certainly judge might speak out, but in limited circumstances. The judge shall still abstain from hot political debates on the reforms, on the legislation, etc., etc. In 2010, we see that already in so-called Magna Carta, the document that actually summarized several opinions of prepared by the Consultative Council of European Judges, the CCJA stated that it's the task of each judge, not just the institutions, not just the presidents or officials who are usually in front of the judiciary, but it's the task of each judge to protect the independence of the judiciary. But still, even in 2013, it is recognized that it is a kind of collective duty. It's not something that each judge should fiercely fight for the independence individually. And actually only in 2019, in the report of the special rapporteur to the UN Committee on Human Rights, we see this summary of different approaches that in different countries where the rapporteur recognizes that it might be that this safeguard, this constitutional safeguard, is not something completely external from the judge. It is not just the environment where the judges have to operate, and it's not just for somebody else, for the society to guarantee the judge this independence, but also for the judge to actively protect it. And in 2022, after the Jura case, we finally see these wordings in the opinion number 25 that probably each judge has this ethical and probably even legal duty to speak out in defense of the rule of law and judicial independence. And to summarize, not only the judicial independence need to be protected by judges by way of speaking, by way of publicly speaking out, but also the fundamental values that our societies are based on. Those are certainly the democracy, the separation of powers, the fundamental rights. That is the area where the politics share the common ground with the matters of justice, of fundamental values. And that's where the judge may and might even be obliged to speak out, especially in this new era where the opportunities for certainly via social networks are open for the judge to participate in a public debate. So I move in favor that the judge now has not only the freedom of speech, not only has the right to enjoy the constitutional safeguard of the independence, but also must use his or her public position in the public debate in defending those values, not only in a particular case, but also in public forums, but also in public discussion, certainly in different platforms. So thank you very much for listening. Thank you. Thank you. Thank you very much.
So thank you for the interesting speech. And we've got our last speaker. It's Alexander Gruber, but he's not in person here. Alexander, are you there, maybe?
Yes,
Yeah, okay, I see you.
here.
Hello.
Please, can you confirm that you hear me?
Maybe you have to turn on your microphone.
I have
Yeah?
it turned on. Do you hear
We
me?
have to do it. He
Okay.
has it already. We don't have.
Okay.
And now?
Okay.
Now it's okay?
Yeah. Do you hear me? Because
Yes. No,
yeah.
we
Do
can't
you
hear
hear
you.
me? Test.
We do.
Because
But you can hear me now, Alexander?
I hear you perfectly.
Oh, now it's okay. Okay, we've got the connection.
Okay. So
Okay.
I'm very
Okay, so
happy.
please let me introduce you. Mr. Alexander Vrubo is finished his PhD and LLM studies at Upsal University. He's the coordinator of the Ukrainian Law School at the Faculty of Law and Administration of the Jagiellonian University. And the topic of his presentation will be Father, Judge versus Observer, Judge, and Ongoing Dilemma from a Comparative Perspective. So, Alexander, the floor is yours, but I can't see you.
Yes, 1 second. I'm now here. So do you hear me? You hear me, and I'm very happy that you hear me. Okay, I was just changing place because I was worried that I would have to give my first presentation at the conference from the corridor of the Ministry of Justice. Was luckily there is some small space where I can work. Do you hear me? Just to double check. Okay, then awesome. I'm very happy to be here today. It's a huge pleasure. And I'm also very lucky that I have a possibility to talk about the topic, which is quite intriguing for me. And actually, it transpired during the lectures with my students. The inspiration was, of course, a Polish legislator who, in 2019, profoundly developed the role of the judge in the civil proceedings. That's why there is a topic. What should be the role of the judge? Whether the judge should be the father to the parties, or judge should be the mere observer of the whole procedural deeds taken by the parties. And I will show you the perspective of 3 countries. Two will be analyzed in depth, and as for the one, I will only mention some solutions. First of all, I will be talking about Sweden. Sweden and Swedish system has a very important and very crucial main role of the judge, and I think that judge has the widest authority and possibilities to influence the parties and the procedure in Sweden. And secondly, I will talk about Poland. Poland now is in the process of transition, which is a bit of a déjà vu due to the fact that probably some kind of solutions which were there during the communist era are coming back in slightly different form, but they are coming back. And the third country will be, of course, Ukraine. But I must say that about Ukraine, I'm a bit humble because there are so many distinct specialists from civil procedure. At least I know few of them are here on the list online. That is why I will only mention a few things. And first of all, maybe we'll also make a spoiler. Majority of students were in favor of judge the father, so judge the protector of the parties, judge who will take care of the parties. Which was for me a bit surprising, but at the same time extremely interesting. I will start with the Swedish system, which is probably most developed from this perspective. I mean, as I mentioned, the judge has the most possibilities to influence the parties. So regarding the solutions adopted in Swedish law, it should be emphasized that at the very outset that there is a code of judicial procedure which is regulating civil procedure and criminal procedure, and it does not contain any general rule concerning instructions throughout the process, because the main instrument of influencing in soft power by the judge are instructions throughout the process. And at the same time, there are some general clauses which allow a judge to interfere with parties of the proceedings and maybe to make them more equal. One of the most striking examples, at least from Polish perspective, is the chapter 12, paragraph 5 of Code of Judicial Procedure. It provides for a situation when a person is already represented by an attorney, including a professional attorney, but the attorney fails to perform his or her duties properly. So the provision stipulates that the court shall ex officio take into account the competence and performance of the lawyer at every stage of the proceedings. In other words, the judge will be this good father and will control whether the party has chosen a good attorney to represent him or her throughout the proceedings. So this section 12, paragraph 5 provides that the court should base its decision on some criteria, and the most important criteria are whether the lawyer performs his duties honestly and competently, and whether he or she has a proper experience which is needed in this case. Of course, in this case, the court's intervention should relate to the specific proceedings and not to the lawyer's activities in abstracto. In other proceedings. In such case, the court will inform the party of the need to change a lawyer, while at the same time relieving the existing lawyer of his duties. According to the chapter 12, section 6 of the Code of Judicial Proceedings of Sweden, if a lawyer or advocate is dismissed in a particular proceedings, the court should inform the party of the possibility of appointing a new lawyer within 2 weeks. If a new lawyer is appointed, the court should approve him, and only then may the proceedings be commenced. And pursuant to its powers under Chapter 12, Paragraph 5, the court may also notify the relevant bar association that the lawyer has been disbarred, which may lead to the disciplinary proceedings. Of course, as an outsider, I was a bit shocked when talking about this solution, but it's quite logical from the Swedish perspective, this father figure of the judge, because the profession of advocate, judge, and prosecutor is regulated in the Code of Judicial Proceedings. Therefore, I think it's logical that the person or the institution which will take control over performing the duties of for example, of advocates, should be the judge. So systemically, it's quite logical. In practice, a lawyer is deemed to be honest if he or she has not committed serious offenses. So it is quite obvious. Then the lawyer should also speak Swedish language, also quite obvious. On the other hand, the justification for the application of Chapter 12, paragraph 5, is that the basic principles of legal professions are performed in a proper way. To illustrate this type of institution, a rather interesting example is one of the judgments of Swedish Court of Appeal, and the Court of First Instance, on the basis of Chapter 12, paragraph 5, dismissed two attorneys from their role as plaintiffs' attorneys. The court pointed out that the proceedings had been pending for more than 7 years due to the lawyer's passivity. In its reasoning, the court noted that an analysis of the attorney's activities during the proceedings showed that there were years in which the attorneys did not conduct any litigation. These circumstances, according to the court, indicated that the inactivity and inability of the said lawyers to bring the proceedings to a conclusion led to the conclusion that they could not be lawyers in these proceedings. Furthermore, the court considered it unnecessary to hear the applicant. Finally, the Court of Appeal overturned this decision, which was taken by regional court, on the grounds that the proceedings had lasted more than 7 years, which was not the fault of the lawyers, and that there were therefore no grounds for dismissing those lawyers. It's particularly interesting also from the perspective of amendments of Civil Procedure Code, which took place in year 2019 in Poland. We have in Polish Civil Procedure General Article 5, which states that if it is reasonably necessary, the court may give necessary instructions on the procedural actions to the parties and participants in the proceedings who are not presented by the lawyer, legal advisor, patent attorney, or General Counsel Office of the Republic of Poland. But this is like general provision, but I think that one of the most interesting solutions here is, first of all, there is a threshold. The threshold is that the person is not represented by the professional, I don't know, attorney, legal advisor, etc. So this should allow the court to be this father to the parties. But then we also have some different articles which are allowing instructions, giving instructions by the court to the parties. These are articles, for example, 210, 162, etc. But one of the most interesting, and which is binding from almost in a and almost not amended, change from 1964, is Article 212, paragraph 2. In the light of this provision, the presiding judge may, if necessary, instruct the parties on the need to appoint a professional lawyer. Of course, the wording of this article is also very interesting, because it does not mention that party should in this situation not be represented by the professional, I don't know, advocate, legal advisor. So in theory, then there can be a situation, theoretically, of course. In practice, it's not, but at least I didn't see any case, that, for example, judge can say that this lawyer is, for example, bad, and you should find another lawyer. So in theory, this instruction is admissible even if a person is represented already by a lawyer. But the general position is that the presiding judge must be impartial when giving instruction, and must not become an aid to the one of the parties. And instructions pursuant to this article may not be in violation of the basic principles of civil procedure, result in the courts assisting in in the effective enforcement of claims asserted by a party. And last but not least, probably the most controversial solution concerning instructions available in Polish Code of Civil Procedure, which is quite new as it was introduced into system in the year 2019. But then now, when I think about the year 2019, totally different era probably of 21st century, and it seems like 100 years has passed since 2019. But for the law, of course, this provision is quite young. I'm talking about Article 156, Mark 1 of the Code of Civil Procedure, which states that the presiding judge may, if necessary, at the hearing, inform the parties of the probable outcome of the case in the light of the claims and evidence presented so far. And this is the first time in Polish history that judge is allowed to instruct parties on merit prior to issuing a ruling. The drafters pointed out that while this solution might induce a compromise, there was a risk that the judge might suggest to the parties the direction of the proposed settlement without a full evidentiary hearing. This in turn may induce the party or parties to the proceeding to enter into a settlement which may be a less favorable offer than the court's decision following the taking of evidence. And the provision introduced an additional possibility for the court or a presiding officer to instruct the parties on the likely outcome of the case. However, this instruction should only be based on the evidence and allegations presented up to the time of the instruction. It is emphasized, however, that such an instruction is of a very exceptional nature and that court or the presiding judge, depending on the stage of the proceeding, should formulate an objective information on the possible outcome of the case. It should be agreed that the court should not go beyond this, as the risk is that such an instruction could, for example, serve as a basis for a motion to disqualify the judge on the grounds of being biased. It is pointed out that such an instruction may provide an incentive for the parties to change their procedural strategy. And of course, once again, from a more general view, it is once again building, to my opinion, a father figure of the judge, so the judge protector of the parties, indicating to the parties that maybe they should change in some way their strategy. At least, probably there is a risk that to a weaker party. Last but not least, I have briefly analyzed the solutions adopted in Ukrainian civil procedure, and they are quite similar. As for general instructions, there is Article 12, which provides the general clause that the court is allowed to, while maintaining objectivity and impartiality, if necessary, explain to the parties to the proceeding their procedural rights and obligations and the consequences of performing or failing to perform procedural acts. There is also Article 197, throughout the preparatory hearing, the court may explain to the participants in the case what circumstances are to be proved, what evidence is to be submitted by a particular participants in case. Juxtaposing the solutions adopted in the system in question, one must conclude that three systems represent the gradual decrease of the role of the court, the judge, from father to observer. So the strongest position is obviously in Sweden, but at the same time, the Polish system is, especially after 2019, changing rapidly into the position of a judge observer, which was so cherished when we changed from a communist era to open market, and now slowly but firmly the role of the judge is changing. Swedish solutions are very interesting, but very interesting from the perspective of legal regulations, since it is legally grounded that a judge can be this father figure for the procedure, because the profession of attorney is regulated in the Act, so Code of Judicial Procedure, where the main role is given to judges and to the courts. And of course, despite the significant differences between the solutions adopted in those countries, but I think that Poland and Ukraine here are closer, apart from this Article 156.1, which allows to issue preliminary opinion on the probable ruling, are developing. It's also very interesting in which way the Ukraine will turn in future. My opinion is, and as it turned out with conversations, in conversation with my students, it is quite controversial that it's not a role of the court in private cases to be a father. The court should be an observer. It should not be additional protector of the parties due to the fact of private cases. But this is not an easy answer, because in some situations, of course, procedure should be elastic. Thank you very much.
Thank you very much, Alexander. So that was our last speaker, and maybe now I will open the discussion. And have we got some questions to our speakers? Yes, please.
My name is Maciej Pach. I'm a lecturer in the Department of Constitutional Law at the Jagiellonian University, and at the same time,
Yeah, come here, please, and ask a question.
Hello, everybody. I'm afraid I'm not Monika Flopczak-Wontor, as it is written. My name is Maciej Pach. I'm an associate professor, assistant professor, excuse me, in the Department of Constitutional Law at the Jagiellonian University in Kraków, and at the same time I work in the office of the Polish Commissioner for Human Rights. And my question is, I address my question to Professor James. And my question pertains to the problem of the Polish National Council of Judiciary. Are you familiar with the topic about the current situation with?
I am not.
Okay.
So I know it exists. I know the Judicial Council exists, but I don't know of the current, any current controversy.
So maybe very, very briefly, 2018, and there was a new bill passed by the Polish Parliament.
Okay.
And the 15 judges who are members of the National Council of Judiciary are now elected by the Sejm, so the first chamber of the Polish Parliament. And earlier they were elected among judges.
So now they're elected by the Parliament?
Yeah.
Okay.
At the time, the Peace Party, so Law and Justice Party, which was governing, told to the society that it is not a problem because Article 187, paragraph 1st, point 2nd of the Constitution from 1997 doesn't speak anything about who elect judges to the National Council of Judiciary. It is only written in this provision that judges are elected, and there are 15 judges out of 25 members of the National Council of Judiciary. Earlier, it was obvious that they should be elected by the judges itself, and now they are elected by the first chamber of the Polish Parliament. So, what's your opinion on this problem, taking into account that the constitutional role of the National Council of Judiciary is to safeguard the independence of judiciary and of judges?
So two things.
We will collect the questions
Ah,
and
ah,
then the answers. Okay.
Okay.
Thank you,
Mogę
Marcin.
sobie pójść, tak?
Yeah. So we've got also one questions from the Zoom. It's Timur Yakimenko. Yeah, you've got
Oh,
the
yeah.
question,
Can
please.
can I start? So my question will be to the last speaker, Mr. Alexander. Can you hear me well? Can you hear me? Okay. I'm sorry. Can you hear me? Oh, yeah. So the question is, the topic is really interesting because in Ukraine, I think we have this active role of judge in administrative procedure. And that's very important because we have a principle according to which a judge in administrative cases can establish facts, for example, and his own initiative. But when it comes to my question is, when it comes to civil procedure, I think every interference of judge might be considered as an influence, as some kind of beneficial action to one or another party. So, and I also want to mention in Switzerland, in Swiss, I think this is a competence of judge is in a civil court, for example. They say if there is no law to apply, judge can act as a legislator. So I think it's also very interesting. And the third, I would want to ask why Mr. Alexander didn't consider France as a legal system where judges are really active and they have even their own detectives. Sometimes they can establish facts. So I think this country is also very interesting to discover this active functions of judge. Thank you so much.
Thank you. Okay, we've got the third question, please. Could you come here and ask the question? Please introduce yourself. Here. Yeah.
Is the
Yeah,
microphone
you
okay?
can speak now.
Okay, good morning. My name is Daria Rożniakowska and I'm a student at the Jagiellonian University, and I have a question for Professor Moliterno. I hope I'm pronouncing it right.
Yes.
I found the notion of examining the ethics of already appointed judges very fascinating, and I was wondering whether you have some experience in such exams that were actually successful and were actually in line with the culture. And also I'm wondering, like, in terms of the future reforms, maybe whether you think that examining judges and lawyers in general in ethics, like when they finish university or when they are applying for their first jobs, is even effective, and what is the right way to do this? And also the third part of my question is whether you have maybe some comments on whether you think that the process of re-educating already appointed judges in some ways could be effective, because I was wondering this before during my course of studies, not only in ethics, but also I was wondering in accordance with, I think that the interdisciplinary approach to legal studies is more recent than most of the appointments of already existing judges. And I was wondering, while I was studying social psychology, for example, or the sociology of law, whether you think there are some ways of re-educating already existing and appointed judges in such topics, because I think they have great importance for like internal judicial independence.
Great
Thank you. Thank you so much.
Thank you. Have we got another questions? Please. Wait.
Okay, so I want to ask you
Uh-huh.
so a question about because you were talking about the independence of judges in
Yes.
context of judicial councils.
Mhm.
But what about United States Supreme Court? Because they are not elected by they're chosen by the president. So how would you describe their independence based on the way they're chosen?
Okay. Great.
Maybe somebody else? No? Okay, so we don't have another questions, maybe here on Zoom. Yeah, okay, Christina.
So thank you very much. Can you hear me? I should, okay. Yeah. So I hope, can you confirm that you can hear me?
Yes.
Okay, so thank you. Thank you very much, our dear speakers, and sorry for these technical problems. I have a question to Jim concerning the post-Soviet or post-communist countries. How do you think what country or countries was or were the most successful when it comes to the legal culture? And actually, when we should start, like I understand that it's a quite broad issue, but I have a question how to improve the situation and when we should start from this school or like what is the best way to start with in order to achieve this level of high level of legal culture in the future for the future generations. Thank you very much.
Microphone, please.
Okay, so they better turn that one down. Yeah. Okay?
No, it's okay.
No.
Yeah.
Are you sure? All right. So there were,
Here.
okay, great. There were 5 questioners. They weren't all for me, but I will do my best on the ones that seem to be mostly for me. And then we will trade to others, I hope. The first questioner, let me try to summarize, had a question about the current Judicial Council in Poland, and in particular, some legislation that was changed by the prior government, the PiS government, yeah. And it changed the selection of the judges on the Judicial Council from being selected by judges to being selected by Parliament. So I don't know, first, I don't know any of the constitution or legislation background in Poland about this. You mentioned an article of the Constitution that they said it's okay because this and that. I don't know any of that. So if I'm wrong on that, it's not me, right? On its face, and knowing what I know about the prior government, I mean, I followed it as closely as an outsider could follow it, but I am an outsider. That seemed to me to pretty clearly be an effort to try to gain more control by the government over the powers within the judiciary. That is, to me, an attack on judicial independence or an effort to have some attack on the judicial independence policies in the government. So I would, in general, I would say it is not a good thing to have all of the judges who are on the Judicial Council selected by the Parliament, right? Not a good thing. There are countries where I've worked where the selection of the judges on the Judicial Council by their fellow judges is also not perfect, right? I know of a couple of countries, for example, where the kind of truly corrupt leaders of the judiciary simply propose the 15 names in that example. And at the event or in the voting, everyone raises their hands. It's a very formal sort of, yes, we say it's okay. So there can be places where selection of the power within the Judicial Council exclusively by judges can be problematic. But in general, it should be the judges who select their representatives, if you will, onto the Judicial Council. So did I answer most of that? Okay, great. Okay, great. The second one, I think, was not for me, but so I'll go to the third one, which was about, do I know of better exams for vetting judges for their own positions? And I understood other parts of that question were Things like, should existing judges go to training exercises? Should they be, you said re-educated? That's a scary word to me, but should they be, kind of grow in their education over a lifetime and learn new tricks, if you will, right? Learn new ways of thinking. And then finally, I think you asked, should law graduates generally have a test for ethical principles before they become an advocate or a lawyer or a judge? So I will say first, in the US, we have such a test that is called the multi-state professional responsibility exam. Everyone who finishes their law degree, their JD, before they can become an active lawyer in the US or judge or prosecutor, they have to pass this exam. Is it a perfect exam? No, not at all, right? It does test whether they know the rules, right? So there is value in it. It does not test whether they are a good person, right? It tests whether they know the rules that regulate them as lawyers. So it has value, but it is not perfect or ideal. So I'm in favor of having that test, but I'm not naive thinking that it decides whether they're a good person or not. I know it doesn't do that. I think the only way for kind of developing over time the traits of what we hope a good lawyer would be like or a good judge would be like are, in effect, traineeships, apprenticeships, these periods of time that in many places lawyers must go through with what we know to be good lawyers, good judges, good role models. These are, to me, the best ways. And so the one place that we know that every advocate will exist at some point is their university, their legal education. And so to me, the professors and the other people who are responsible for the students' education need to be good role models about what the kind of aspirations should be for the kind of person as a lawyer, the kind of person as a judge that will make our country work better, right? Be good for our citizens. So acting as role models, I think, leading in those ways are the best ways to develop over time the entire population of lawyers or judges who will understand their role is to make their country and their citizens better. That's their job. It's not their self-interest, right? Too often I have seen judges in some countries who believe, for example, that judicial independence is a property of theirs, that they own it, right? It is a protection of me, right, against intrusion. They think of it as something they own. I think of judicial independence as an instrument of good justice. Judicial independence is meant to keep judges away from interference by state actors, especially with their decisions, so that they can give impartial judgments for the parties to cases that come before them based only on the law, only on the facts, right? And so judicial independence isn't a thing that's owned by judges. It should be understood as something that exists for the purpose, whether it's in the spirit of the judge or in the structures. Both are important. I agree 100% with the comments you made about it. It exists for the purpose of making justice better for the country and its citizens. That's what it's for. So how do you do that? I think you do it by role models. You do it by traineeships, by influence of good conduct around you. Do I know of a better exam than the one that was given in Kosovo? That's actually a great exam if it's given to people who know that kind of test. It's okay, but it was wrong for that setting. So to me, I guess if I were designing that sort of re-vetting all the judges, I would do it through interviews. I would do it through the financial disclosures and investigations that we can conduct to try to understand how a judge who is rich became rich, right? I mean, they may have family that is rich. It's okay. I don't begrudge someone who has money. It's all right. But if they got rich the wrong ways, it's not so good. The other thing, for example, about that effort in Kosovo that was all wrong is that at the time, the salary for a judge was so low. It was so low that a judge actually couldn't have an apartment even. And so the system was almost designed so that they would take bribes. It was almost designed so that that was part of their income expected by the way they were paid. Anyway, so I don't know if I've answered most or all of your question or some of it. Okay. Let's see. Then the fourth questioner asked about the U.S. Supreme Court and its independence. So it is very independent. It is selected, as you know, nominated by the president at the time and confirmed or not confirmed. Sometimes we've had nominations not confirmed by the U.S. Senate. So most of the time, but not always, the U.S. Senate is controlled by the opposite party of the president. And as a result, when that is the case, the president is constrained a bit about who they can nominate because they have to know they will be able to get their choice through maybe an unfriendly U.S. Senate. So it's a moderator of extremes. It's a moderator of extremes. Now, the last 3 appointments we've had were a Republican president, a Republican Senate. It produced the results that it produced. But most of the time, there is this moderation. Once a justice is on our Supreme Court, historically at least, they have exhibited great independence. There are many, many, many cases, important cases in history that were decided by Supreme Court justices in the US in ways that would be 100% against the interests and wishes of the president who appointed them, maybe 10 years ago, 20 years ago, whatever, because they have life tenure. So they are very independent. I don't like our current Supreme Court. That's my opinion. I don't actually like some of their activities. Maybe you have been able to follow that at least 2 of our 9 justices have in recent years been receiving hundreds of thousands of dollars worth of free vacations and trips. One of our justices has been on island trips in Thailand and in Bali, in Indonesia, on a luxury yacht, flown there on the private jet of somebody who is a very strong activist, not a party to litigation, but a very strong activist, anti-abortion activist, anti-LGBT activist, etc. And this guy pays for these things for this justice, and that's troubling to me, very troubling to me. So there are, and I've written op-eds about it, that are published, so I'm not telling you any secrets. So there are things about our Supreme Court right now that make me very, very unhappy. But they do have judicial independence, right? They do have. And I don't know if I've answered. Okay, great. And then the last one that maybe was for me, most successful post-communist country in terms of developing their judiciary in particular. I think I want to say Czech Republic. I think that until the attacks of a few years ago, I might have said Poland was in the running for having a very, very strong constitutional court, a very strong structure for its judiciary. And we hope now some of that is going to be restored. I don't know. I'm speaking in a room of Poles, so maybe I shouldn't do it. But Czech Republic has done it very, very well, I think. Slovakia was making a lot of progress until the new Fico government from, what is it, maybe 6 months now only, and it's very, very dramatic and unfortunate, in my judgment, changes. Hungary, yeah, with Orban is, they're the very powerful attacks and efforts to capture the judiciary for the benefit and use of the government, right? These are very unfortunate events that have been taking place. Czech Republic has mostly, not entirely, avoided a lot of those things. Georgians, my Georgian friends, if there are any still left on the call, are working very hard, but it's a struggle too. I don't know. That maybe didn't answer your question. All right.
And, Timur is raising his hand.
But there was
Yes,
also a question that was, I think,
Timur.
yes. Okay. Great.
Thank you so much. My name is Timur. I'm a PhD student at Yaroslav Mudr National Law University.
We
Mr.
can't
James,
hear
thank you
you,
for
We
your.
can't hear you yet.
Can you hear me?
Yes.
Now we can.
Oh, sorry. My name is Timur Ekiment. I'm a PhD student at Yaroslav Mudr National Law University. Thank you so much, Mr. James, for your presentation. And first of all, I would like to make a remark. You mentioned that independence of judicial.
Wait, please.
Is that okay? Can you hear me? I cannot hear you, unfortunately. Just a second.
But we can hear you.
Can you hear me? Yes. So I would like to pay attention. There is an American scholar. His name Adrian Vermeule, and he said that sometimes we treat the principle of separation of powers as an idolatry. So we like something sacred, and if it's misunderstood, it can lead to the consequences detrimental to law itself. And this is what you're talking about, because you say an independent judiciary, if it's completely uncontrolled, so how can it can be detrimental to the legal system itself. And but my question is, maybe when there's a corrupt judiciary, for example, it might be detrimental not only to individual cases, but to the legal practice, to the legal system at all. And I know in United, I just want to ask your opinion about judicial deference in the United States. When judges, like Chevron deference and other cases, when judges should defer some interpretational issues to a lawmaker itself or to some agencies, or for example, in the state of Louisiana, there is an interpretative laws. So actually Parliament can interpret legislation retrospectively. So this topic of my research, but I just want to think, is it a good tool in order to keep corrupt judges controlled, for example, to avoid some big problems by wrong interpretations, when judges have to defer some questions, when they defer in interpretation to legislator? And what is your opinion? Thank you so much.
You hear me? Can you hear me now? Okay. So I think you are studying this as an academic purpose. Yes, all of these questions. And
Yes,
I think
yes.
you have just asked several questions that we should spend 2 or 3 years debating and discussing. They're enormous questions. But I will do my best to say a little bit. It's okay? So I know Adrian Vermeule. I know him. I've met him. We have chatted about different things. I am not a constitutional scholar. So I am stepping into an area that is not my field. I am a legal ethics scholar, mostly. I do not like some of Adrian's articles and his positions. I am not a fan of his positions. I think they have the potential to lead to very unsettling and troubling results. So first of all, I am not in favor of most of what Adrian says. Second part, you asked about the Chevron doctrine. And I guess I need to say the Chevron doctrine in the US is a doctrine that came from an important US Supreme Court case from the 1980s. The Chevron doctrine said that when a federal judge is interpreting a regulation from an from a statute from the Congress and then an administrative regulation from some administrative body, when a judge is interpreting it, the judge should defer to the understanding of the administrative agency. This has always made sense to me, good sense to me, because the administrative agency is made up of scientists. It's made up of people who are studying these questions for a living. They know how the environment works. They understand what water is clean and what water is not clean and things like that, right? Judges, in my experience, do not. We are experts at different things, but not usually environmental science or other kinds of scientific things. Maybe you know, is it Timur? Timur. Timur,
Yeah.
maybe you know that our Supreme Court has reversed the Chevron doctrine just 3
I
days
haven't known
ago.
that. Oh
3
my
days
goodness.
ago.
Oh my.
It's gone.
Thank you.
The Chevron
Okay.
doctrine that you're asking me about. This is very disappointing to me in US law, because it means that a judge will have to make these scientific decisions. Yes, they can hire experts. They can, have expert witnesses. It will help, but they no longer are required by law to defer to the studies of the administrative agencies that were undertaken to approve a drug or decide how clean water has to be safe, or any of these things. So judges are going to decide these things. And I love judges. I really do. But I couldn't do any of those things. I couldn't decide what water is clean or not clean. I don't know how to do those things. I would just need to rely on some other experts. So the Chevron doctrine, it's gone like 3 days ago. To
But
me,
there were
this is
two other
very
decisions.
disappointing.
Let me roll
I don't know. I think you asked one other question, but I'm sort of, they're giant questions and have big impacts. And even the Chevron doctrine already means that the abolishment of the Chevron doctrine already means that we are going to have more and more and more judges substitute their opinion about very technical things over that of administrative agencies that studied it for years to decide these questions. So I don't know if I answered enough of your question or not.
Thank you so
Okay,
much.
okay.
Thank you. Thank you.
All right, he says thank you. But somebody asked a question about French judges, and it wasn't for me. I think the question was for our third speaker, maybe. Yeah.
I asked about.
Oh, he
French
had to
judges.
leave. Okay, so.
Here.
You want me to move?
Could you?
Yeah, I can move.
So I think we can close the discussion.
Just people would like to comment.
Sorry.
I would just
sorry.
add some brief comments. I completely agree with what dear professor just talked about the deference to the interpretation of specific rules, especially where other areas, not just what should be, what's the best way to organize some relations in the society are involved. I mean, scientific knowledge should be deferred. And that remind me one joke from my arbitration practice. Who is the witness? It's the one who remembers something but does not understand what was it about. Who is the expert witness? Is the one who doesn't remind any facts of the case, doesn't remember, doesn't know, but who understand how the things operate. And who is the arbitrator who is going to solve the case? It's the one who doesn't remember anything and doesn't know how the things operate. So, of course, this has nothing to do with the judges, but they still do need to defer the professional approaches. And I might probably answer that question that was addressed to Alexander Vrobel. I'm highly in favor of making the procedure, the civil procedure especially, effective as much as we can. And certainly the effectiveness, the efficiency of justice sometimes stands contrary to the fairness of the procedure, and sometimes has not simple relations with impartiality. But still, the judge, I believe, has this opportunity to comment on possible outcomes. We need to strictly apply the procedural rules that will not allow the party to make these shifts at the procedure where it's already too late to provide, for example, some new evidence or to change completely the strategy on the case. But certainly the judge might and should stimulate the parties to find an amicable solution. And for me, it was also something not new, but not quite understandable when I came from arbitration practice, where I, as an arbitrator, could provide the parties with my views on what I will decide unless something will change. Even more, I could provide the parties with the draft of my final award, so that they can see that and think twice whether they want this or whether probably they find a peaceful solution. So I'm strongly in favor of allowing the procedure to be divided into steps that can make the procedure predictable for the parties and outcome predictable for the parties. Thank you very much. Thank you for allowing me to comment on a question that was not primarily addressed to me directly. Thank you.
Thank you so much for the panel session. And now we can close the discussion officially. And I would like to invite everybody for the coffee break now. Yes.
Yeah. And we will meet in 15 minutes.
Okay, and we've got 15 minutes and we'll be back.
Yeah.
Thank you.
Thank you very much. So we would like to invite you to the other room. There is the coffee which is waiting for you.
On Zoom. Okay. Before I begin, first of all, I would like to congratulate Monica and Christina on your brilliant achievements, brilliant ideas. It so happens that this is the second time I convene one of the panels of their conferences. We opened the academic year with your conference, and I had the pleasure to preside over one of the panels, and now we are finishing the difficult and academic year with your conference, concluding, as I understand, conference. So it's my pleasure and honor, of course. And let me, of course, also welcome our distinguished speakers. and we will keep this order as in our program. The first speaker will be Professor Olena Kibenko, who are on Zoom with us. She's a professor and also a justice of the Supreme Court of Ukraine in the Grand Chamber. Olena, the floor is yours.
Thank you very much. Actually, it's a great honor and a great pleasure for me to be here. I'm very
we can hear you.
Okay, I'm very thankful for organization of such remarkable event, and I'm happy to be here and to share my thoughts. But first of all, I would like to share my presentation. Can you see the presentation now? Sorry, do you see the presentation? I cannot hear you.
I'm sorry. Yes, we can see the presentation. Yes.
Okay, thank you very much. So I can proceed. I'm happy. In my presentation, I would like to discuss the practical problems with the application of foreign law faced by Ukrainian judges. Today, sorry, I cannot move my presentation. Wow. Oh,
It's moving.
Yeah, it's moving. Okay. Today, Ukrainian courts are increasingly deal with the issues of applying foreign law in disputes involving foreign element. However, this trend is typical for judges around the world and has even been called judicial cosmopolitanism. Courts apply foreign law not in cases courts apply foreign law not in cases with foreign elements under the choice of law, but also when dealing with complex issues that have not yet been faced by national courts of a particular country. Oh, sorry, I have some problem with presentation. Oh, I think it's some technical problem. They cannot move as it I planned.
It's working. It's working.
Yeah, so we have two cases of application of foreign law. First, it's cases with international elements, foreign law, when foreign law applied according to the choice of law rules or according to the party's choice. And second, when judge decide untypical complicated cases, judges also look how these complex problems are resolved in other jurisdictions. And we are talking about application of foreign law in this second cases. But in my presentation, I would like to tell you only about the problem which we have in first type of cases. And to demonstrate this existing problem, I chosen only one case recently heard by the Supreme Court, but this case I think is very indicative. In this case, the Supreme Court applied the law of England and the BVI to determine whether a company that had been struck off the register could participate in general meeting of shareholders of the Ukrainian company, given that it subsequently been restored to the register. So it's a little bit complicated for Ukrainian judges issues. And the Supreme Court applied the UK Companies Act 2006 in this case and relied on opinion on legal expert provided by one of the parties. And I would like to mention that the two judges have dissenting legal opinions on this case, and I am one of them. And I would like to use this case to explain where I see the problems regarding the application of the foreign law. In theory, everything should be perfect and clear. we have Article 8 in the Private International Law Act 2005. And it provides a procedure for determining the content of foreign law provision by court is set out in this article. And it states when applying the law for its state, court shall determine the content of its rules by their official interpretation, application, practice, and doctrine in the relevant foreign state. Moreover, this article also states that to determine the content of the foreign law, a court may apply under the procedure established by law to the Ministry of Justice of Ukraine or other competent authorities and institutions of Ukraine or abroad to engage the experts. Parties have the right to submit documents confirming the content of foreign law rules, which they refer in substantiating their claims or objections, and otherwise assist the court in establishing on the content of these rules. Moreover, we have a perfect decision of our great chamber as the great chamber of the Supreme Court. This is part of our Supreme Court that decide organ that decide more the most complicated issues. And in this decision, the Grand Chamber set out the rules on how a court should establish the content of foreign law. In particular, it noted that it's court obligation, which cannot be passed to the parties. This next slide, I would like to show this very, very important provision of this decision. But on the next slide, you can see the range of issues we faced in this particular case. I would like to, it's so slow, sorry. Oh, you can see that now, I hope. For example, first of all, the problem was that, and we mentioned that in our both dissenting opinions, that the expert opinions submitted by the plaintiff in this case were prepared by an expert who cannot be considered and recognized expert in British corporate law and who didn't confirm his specialization in the issues that were put in. Expert provides only a copy of his PhD certificate and copy diploma and copy of assistant professor's certificate. The expert doesn't provide any information about his education or teaching career, which would indicate that he studied at the UK or taught British corporate law. The topic of his dissertation research not related to either UK corporate law or Ukrainian corporate law in general. Public sources of information on academics show that this expert has no published work on British corporate law or Ukrainian corporate law. And the expert doesn't provide example of participation in the consideration of such disputes in courts in the UK or even in Ukraine. However, majority of judges in this case believed that since the current legislation doesn't contain any special requirements for experts, sorry, it's too quick, doesn't contain any special requirements for experts, the legal professional with a doctorate degree or professor diploma can be considered as an expert, no problem. They cannot see any problem in that. And moreover, the judges believe that the court should not have to search for foreign law itself. For example, I studied British corporate law for 20 years. I have two published monographs on this field. And I was completely disagreed with the opinion of the expert in this case. I think it was wrong because he doesn't use any case law to interpret the Companies Act. He doesn't use any doctrinal sources and so on. But colleague doesn't agree with me, didn't agree with me, sorry. Here we differed with Judge Vronska, who wrote the second dissenting opinion. I believe the court could determine the content of foreign law itself through an internet search or doctrinal resources, and only if it's not possible, court could send the request to the Ministry of Justice. And Judge Vronska thinks that we cannot find the law by ourselves. We cannot search the internet. We cannot search the literature. We just need to give our request to scientists. We have a special organ at the Supreme Court. And Vronska thought and wrote in her dissenting opinion that the Supreme Court should find an expert among the experts that are members of this organ. A lot of another questions arise in this case. For example, if I know English and I can find foreign law from, I cannot see any difficulties to find the British Companies Act in the internet. Can I use it by myself? How I can translate this Companies Act, because, for example, our judges from my panel don't know English, so I need to translate these sources for them, or, for example, case law or doctrinal sources. Can I use exist special computer program for to do this translation? I mean, Google Translation, DeepL, or some other programs. They are very popular now, and they make good enough translation. And how I can do that? Do I put all this, my finding, I mean, the text of Companies Act, text of case law, text of doctrinal sources into the case materials docket, into the case docket, and how to do that? We have no any such rules, and we have no procedure. So in theory, it's everything is very okay, and we apply foreign law, but actually, a lot of questions arise, and I can show in this particular case. And to avoid reinventing the wheel, I started searching the internet and found a very useful source of information on all these issues. I mean guidance, Hamburg's rules, guidance for ascertaining and applying foreign law in German litigation 2023. And actually, in this source, I found a lot of useful information, and I found answer for all my questions regarding this case. For example, next slide. I am waiting. For example, very, very important rule. I tried to persuade my colleague in that rule, but unsuccessfully in this case, that the foreign law only requires proof to the extent that is unknown to the court. That means that in particular, that the court may and often can determine the content of foreign law through its own research, primarily with the help of accessible literature, internet sources, and translation programs. And this is the answer for all my questions. And I am happy that Hamburg's rules, Hamburg guidelines provide us with these principles. Another very important provisions that judge should do that if decision depends on the foreign law, the court must discuss this with the parties. Wait a moment. slow presentation again. So if the decision depends on the foreign law, the court must discuss this with the parties to have a fair hearing and give them the opportunity to present their views on the determination of this content. If the court has formed a preliminary opinion, of the content of the foreign law based on its own research. It should communicate this to the parties. It's very important because we have no such procedure in our procedural code. We have no such recommendation from the Supreme Court, for example, and usually our court, Ukrainian courts, don't do that. Next important rule, next my finding, it's demands for the expert. You can see that Germany, in Germany you have Germany have many demands who can be an expert in the case. For example, a previous experience in the legal system in question is desirable but not strictly necessary. Solid knowledge of private international law in general, comparative law is also desirable, but desirable, not necessary. But what is necessary? Whom can be an expert? Members of academic institutes for foreign law or university lecturers with relevant qualification. With relevant qualification, but also independent experts. So the first demand, it's regarding legal profession. And next, it's very important, who have special knowledge of a foreign legal system due to studies or admission to the bar there, and may be considered as experts. So it's very important. And if we apply this rule, it's our experts in this case that I have mentioned are not good expert for the Supreme Court for this case. And I would like to also mention that it's also possible to appoint expert from the relevant legal system itself, but Hamburg guidelines tell us that that can be some advantages and disadvantages of such decision. So it's not necessary. And finally, I also think that it's very important that the reasons for the decision must show how the foreign law was determined. We never put this in our decisions, and I think it's a very important rule. It's a very important prescription, and we should do that in our decision, describe how we find foreign law to make our decision more reliable, more understandable for parties. And if we say about trial court, about the court of second instance, it's easy to make appeal again such decision to the Supreme Court if court describe the procedure of finding foreign law. And in conclusion, I would like to say that we have to work hard to improve our practice of application of foreign law. And the first steps, I think, should be to write a guidance for Ukraine, like Habsburg's principles, Habsburg guidelines. And also we can organize some training program for judges covering international private law, international commercial law, and other topics that you can see. And I think it's important to improve language proficiency. So some language study program is necessary for our judges because we face the problem of applying foreign law more quickly than it was before. Thank you for attention. If you have any questions, I would be happy to answer these questions. Thank you.
Thank you very much, Elena. Analyzing the relationship between national law and foreign law seems to be very important, especially in the context of a candidate country, I mean, the European Union. And I remember that my first research paper concerned these issues when I was a young PhD student. And these issues, to some extent, will be continued today by Dr. Nazari Stetsik. Sorry for my pronunciation. He is a visiting researcher at the University of Vienna, and in the Ludwig Boltzmann Institute of Fundamental and Human Rights in Austria. And his presentation is entitled Engagement with Foreign Case Law, Comparative Lessons for Ukrainian Constitutional Justice. So the floor is yours, and as I understand, you are going to use your own laptop.
Yeah, do you hear me well? Do online participants hear me?
Yeah, we can hear you.
On Zoom, yeah. Okay, thank you. Dear organizers, dear participants, first of all, let me express my heartfelt gratitude for the invitation for having me here. It's a real pleasure and honor to be here with distinct professors, honorable justices, and especially also with students to share my expertise, my knowledge. This project is very valuable, and I really appreciate that this final event is in person, and we can share personally our results of our research. I propose the topic of today's speech about the improving of constitutional justice in Ukraine, and somehow my speech will be related with what Honorable Justice Kibenko described, but on the examples of constitutional justice comparatively and in Ukraine. And we all are aware about the criticism and negative remarks about the operation of constitutional courts of Ukraine. I agree with that. Our Ukrainian Constitutional Court should have been more actively operating before the war and even now. But it does not mean that we should not propose some positive remarks for improving constitutional justice. And one of this way to improving constitutional justice is the involvement or engagement foreign materials in adjudication of human rights cases by Constitutional Court in Ukraine. For several years, I have already been specifically studying how constitutional and Supreme Courts abroad, foreign courts, are engaging with foreign comparative materials. And even before the war, we with our distinct host, Professor Monika Florczak-Wentor, were initiating one project, and I'm really grateful that you supported this initiative at that time. So in my speech, I will cover a few issues. First, I will start with terminological introduction about what I mean actually by foreign case law, and what does it mean to engage with and to involve foreign materials. Justice Kibenko has already described some applied issues, and I would start with more general doctrine vision. What is foreign case law, and what does it mean to engage with or involve foreign materials? I understand foreign case law as decisions in complex and hard cases which contain positions or arguments that can serve as an example or models for consideration in similar cases by foreign courts. And it is important also to note that it is not the broadest term. The broadest term is foreign comparative materials, and they include actually legal foreign materials and not legal foreign materials. What I mean by this distinction is actually important because non-legal materials include also sociological data, include some scientific research. And what most important is that foreign decisions, they can serve as source of these non-legal materials. We can find in different courts, foreign courts, especially in common law jurisdiction, when they cite, quote, not just constitutions, not just foreign decisions, legislation, but also some research, very, very interesting research, which can be decisive for the resolution of some case. And in this sense, foreign case law covers not only the decisions of the courts themselves, with the relevant points and reason, but also the non-legal materials they contain. And as for the term engagement with or involvement, these are most general terms, and they reflect the broadest range of possible ways and forms of working with foreign case law, from its usage, reference, application, citation, and even hiding use. And the engagement with comparative materials is often discussed alongside other related concepts and doctrines and even metaphors, such as borrowing, migration, cross-fertilization, cross-pollination, transjudicial communication, transjudicial dialogue, and even ping-pong jurisprudence. And in this sense, I would also point out that Harvard Law law school professor Vicky Jackson has actively used in this context this most broader term engagement. And secondly, I want to offer several, actually 4 lessons for constitutional justice of Ukraine, which I briefly name and describe their content. So the lesson first, I would call it the lesson of legitimacy, or why the court should turn to foreign case law. Justice Kibenko described cases or instances when ordinary courts engage foreign materials, foreign case law in the relations with foreign allies. And the legitimate ground for that is national legislation. For example, if we also apply European Code of Human Rights, the legitimate ground for citing it, for involving it, is of course international obligations which derive from the European Convention on Human Rights, and in the case of Ukraine, national legislation of Ukraine. But what about, and in terms of foreign case law for constitutional justice, there is no such legal ground. And why foreign court needs to look abroad for this case law materials? And this answer is not, this question is not quite obvious and unequivocal. As Richard Posner, a justice of the Federal Court of Appeals of 7th Circuit, once put it in the context of foreign case law involvement, quote, "No sense, we already have our own laws." Or, for example, U.S. Supreme Court Justice Clarence Thomas, in one famous decision, he drastically called it, quote, "foreign moods, fads, or fashions." And there is no legal ground. And in my opinion, the lesson for the legitimacy of foreign case law for the constitutional justice of Ukraine should be based in 3 main points. First, it is the complexity of the case, which consists of the lack of a clear answer in national constitutional law and calls for recourse to the foreign experience. And especially in the case of European integration of Ukraine, it is important not to reinvent the wheel on our own, but use the experience of European countries that have already faced similar cases in their case. The second point is the universality of human rights provisions and the nature of human dignity, which determine the appeal to the consensus of foreign countries. And as aptly pointed out in one of the recent studies, that human rights are not one of the most fertile grounds for transnational judicial dialogue and exchange. And the third point is for legitimacy is the customary practice of involvement and citing foreign decisions. In other words, if in some cases the court, for example, Supreme Court, refers and cites foreign decisions, it means that in other cases, the parties in the proceedings will also draw the court's attention to foreign decisions that will be in their favor. Lesson 2, or lesson of relevance, or context does really matter. As Professor Moliterno today pointed out about the relevance of tasks from the U.S. Law teaching to the Kosovo judges, and it raises this issue of relevance. And this issue has 2 dimensions: one related to the relevance with the context of a specific concrete case, and the other concerning the relevance with a broader framework of legal system or legal tradition. As lesson for the constitutional justice of Ukraine, it is crucial to take into account these 2 options: concrete case and broader framework. For example, the social, political, and economic and cultural context in certain decisions are delivered in some countries may differ significantly from the Ukrainian context, and especially this context will be different in their post-war reconstruction of Ukraine. And for example, political regimes in which foreign courts operate are also different widely. For example, it is obvious that the involvement of comparative materials from the Constitutional Court of Belarus or Russian Federation is completely irrelevant from a broader contextual perspective. And similarly, the practice of constitutional justice in populist regimes, which with the captured and packed courts may also be questioned. The relevance of the legal context of specific case should also be considered, because different constitutional provisions in various countries differ greatly. The procedure standards of constitutional review also differ. Circumstances of specific cases and particular content of challenged legislative instruments are filled with many nuances. And this multiplicity of legal context of concrete specific case must be studied in detail by constitutional justice when they want to apply involved foreign case law. And next lesson 3 is a lesson of authority, or why the court should pay attention to complexity of persuasiveness. This issue is complicated. Maybe it will be hard to perceive it in the tired mind, but still I will proceed. First, it relates to the very force of foreign comparative materials. Second, concern the potential multiplicity and contradictions within foreign case law. And third, deals with the potential change and development over time. As Professor Moliterno just mentioned that Chevron doctrine has gone, and they develop, or case Roe v. Wade has gone, and actually case law is has a trait to be developed, in either ways, bad or good, And most research approaches agrees that foreign case law cannot be absolutely binding for judges and can only possess persuasive authority. What does it mean, persuasive authority of foreign case law? It lies in the notion that courts may choose to reject these materials by presenting opposing arguments. And conversely, when courts take relevant comparative materials and arguments into account, these materials are not decisive for the outcome for the case, but serve to strengthen the court's reason. And next, the authority issue of foreign case law also extends to the multiplicity and inconsistencies with foreign decisions. When foreign case law materials are harmonized, consistent, and coherent on a particular issue, they carry greater persuasive authority for the court. And strong arguments must be presented to disregard them. However, the persuasive force of foreign case law materials diminishes when they are characterized by contradictions and disruptions. In such situations, the court faces a dilemma, having to choose between conflicting points and arguments presented by different foreign courts. And another noteworthy challenge is the evolving nature of foreign case law over time. Foreign courts may overrule their opinions in new analogous cases, leading to the development of foreign materials in their original jurisdiction. Are the grounds for overruling a previous decision by foreign courts authoritative and persuasive for another court? To what extent should such changes in foreign jurisdictions influence the validity of reasoning and the outcome of the case where the previous, now overruled foreign opinion was applied? Does it necessitate reconsideration maybe and a new decision in such a case? These questions are not mere speculation, believe me, as the real instances of such situations are observed in the practice of involving foreign case. And the last lesson is the lesson for dialogue to dialogue. And it means that don't just refer and quote foreign case law, but position yourself with this foreign case. In many countries, there is a practice of engaging with foreign case law by simply quoting foreign decisions in a separate section of relevant decisions. The practice of Federal Constitutional Court of Germany can be an example. However, it is often unclear what argumentative value these quotations hold for the outcome in the case. Such involvement of comparative materials can sometimes appear as mere window dressing or a demonstration of wide erudition of individual judges or courts. And in some cases, it resembles a guide, like textbook of comparative legal studies rather than a substantive engagement. And for the Constitutional Court of Ukraine, it is crucial to relate itself with foreign case law. And the court does not always have to accept all comparative arguments and may not agree with some of them, but it is important to engage critically and meaningfully with these materials. And attention should also be paid to the differences of reasoning styles in various jurisdictions. In common law countries, the reasoning style promotes such a dialogue, allowing judges to individually express their opinions in relation to the fellow judges and the position of foreign courts. And in contrast, many countries in civil law tradition, given the legacy of legal positivism, have limited the dialogical engagement. Also, in some countries, the need to make anonymous decisions without the possibility of expressing dissenting opinions affects the dialogical engagement with foreign case. Also, I have another different lessons for the Constitutional Court of Ukraine, important actually lessons about how we can misuse or abuse involvement of foreign case law. It's actually the problem, of course, of selectivity or cherry picking, ornamentation or window dressing, hidden involvement, or copyright integrity. It is curious, Professor Moliterno, whether is it a breach of legal ethics when some judges take foreign case law, use it actually, but does not sit. Is it integral? For students, it's not integral. When they write an article, they can be, yeah, but judges, some judges do it. Yeah. However, due to the lack of time, I cannot cover them in detail here. So in my presentation, I justified the importance of referring to foreign case law for improving the operation of Constitutional Court of Ukraine, especially in the context of European integration. I briefly explained the terminological understanding of foreign case law and the forms of its engagement, and the following comparative lessons for the constitutional justice of Ukraine were highlighted. It was the lessons of legitimacy, the lesson of relevance, the lesson of authority, and the lesson for dialogue. I hope that Ukrainian constitutional judicial will improve the performance of its tasks and functions in the near future, which I sincerely anticipate. And at the end, and as a sign of hope and a glimmer of light, I present the latest statistics for this year. As of today, the Constitutional Court of Ukraine has referred to the case law of foreign constitutional courts in three judgments of 7 delivered in 2024. Specifically, in one case, it referred to the opinions of constitutional courts of Lithuania and Latvia, as well as the Supreme Court of Estonia, and in another case, it quoted the judgments of the Federal Constitutional Court of Germany and Constitutional Court of the Republic of Latvia. And in the most recent decision dated 19th of June, the court referred to the case law again to the Federal Constitutional Court of Germany and the Constitutional Court of Republic of Croatia. Of course, qualitative substantial analysis need further investigations. At this time, I thank you for your attention and will be happy to answer your questions. Thank you.
Thank you. Thank you. It was very interesting. I think we are going to change our subject slightly as to the next two presentations may interplay with each other. The first will be the first talk will be about the institution of constitutional complaint. The second about the Polish constitutional crisis, namely the Polish constitutional tribunals crisis, and why they may interplay with each other. There were a lot of debates in Poland concerning the scope of the institution of constitutional complaint. Whether the scope should be narrow as at the moment, or should be expanded, and German and Austrian examples were analyzed, but all these debates have been muffled, I have the impression, because of the Constitutional Tribunals crisis. So Matthias' presentation is entitled "The Individual Constitutional Complaint, the Citizens' Protection, the Court's Burden, Why to Appreciate and How to Handle It." And as I understand, you are going to use this computer and you have
Yes.
the presentation, your USB.
Yeah, can you help me with just so in first line?
Sorry, just I didn't introduce you in terms of your affiliation. I'm sorry about this. Matthias is a researcher at the Max Planck Institute for Comparative Public Law, International Law in Heidelberg, Germany. Sorry about this. Floor is yours.
No problem. In first line, I would really deeply thank you for the invitation to this very prestigious university, one of the oldest in Europe. And it's not the first time that I'm here at the University of Krakow, but I always like to come back. It's a very specific town, city, Krakow, and there's a specific university. And in this context, I must say, it has a specific purpose. And I admire your achievements up to this point in the cooperation between Ukraine and Poland. I think Poland was one of the strongest backers of Ukraine in these difficult times. And yeah, this university can be proud to have such a program here. So I'm very happy that from the sideline, I can also participate to a certain degree. This for the beginning. The second, I would like the trams. They remind me of an old joke. A lady buys a wardrobe with IKEA. You know, everybody knows IKEA. And she says, I have some talents and I will set it up by my own. And she goes home and sets it up. And then when the first tram passes in front of the house, the wardrobe comes down. She's upset and she calls IKEA. IKEA says, this evening we will send you our technician, he will set up the wardrobe again. And he comes and sets it up. The tram passes, everything is fine, and he says, but I will check it. He crawls into the wardrobe, closes the doors in order to see if it's really stable, also with a certain weight in it. At this moment, the husband comes home and says, oh, darling, you bought a wonderful wardrobe. Let me see how it looks from inside. And he discovers the technician. And the technician says, believe it or not, I'm just checking. I'm just waiting for the next tram. So far, coming to the topic, and here to my methodology. I'm a lazy man, and I will also involve you. I will put questions to you, so be aware of it. And I hope you can answer the one or the other. And it's not, wouldn't be a fault if you're unable to answer it. You know, we should develop the topic together. You know, that you are actively taking part in what we are talking about. My topic is the individual constitutional complaint. And now my first question is, who's from Poland? Who's from Ukraine here? Half and half from Poland? Ukraine. Ukraine. So what about the constitutional complaint in Ukraine? Can you tell me something about it? The constitutional complaint at the Constitutional Court. Individual constitutional.
Christina, yes, it is.
Sorry? Yeah, but the students shall answer. The students, no. No. Here, the audience. Do you have any idea about it? Can you go, somebody, the policeman abuses you in a way or another, can you bring the case before the Constitutional Court? Speak up, because, you know, we have to go to the air, you know.
Before we are in Constitutional Court, we should go through a few explanations. I have like a general understanding of individual complaints. Not sure if I'd like to hear something from you about constitutional complaints.
Yeah, can you go against this abuse by the policeman? If he brings you to prison without asking a judge, can you go before the Constitutional Court in the end, in Ukraine?
I'm pretty sure we can.
You can? What? We'll answer this later.
And our law which came in force about mobilization. Yes, I think it's a constitutional law, right?
Mhm.
I'm not lawyer, so yeah. So, and I think nobody has any ability just to go and to fight for your rights, unfortunately. And it's
Nobody can.
absolutely different national.
But there is an individual constitutional complaint in Ukraine. Yeah, there is one. And this is, you must know this because this is a very important topic I'm talking about. It's a constitutional complaint. I would say this is the masterpiece of constitutional jurisdiction. There are different procedures, but the individual constitutional complaint is a masterpiece. But it differs. We are talking about comparative law. It differs from country to country. And we will focus a little bit also on the differences between our different legal systems. And this for good reasons or not, we may discuss it later. But this is an important point. You have a constitutional complaint. What about Poland? We will come back to the specificities in a while. Yeah, this is, I must say, in Germany and other countries, the most efficient remedy for the protection of fundamental rights. You may ask, is it necessary to have an individual constitutional complaint? Because this notion is linked to the Constitutional Court. You can make a constitutional complaint before the Constitutional Court. In Germany, as in all your countries, here in this case, in Poland and in Ukraine, all state organs are bound by the Constitution. It's not only for the Constitutional Court, it's not only for the government or the parliament, it's for all state organs. They are bound by the Constitution. They have to respect the Constitution anytime. It's a very important thing. So also the ordinary courts, civil courts, criminal courts, administrative courts, they have to take into consideration the Constitution when handing down a decision. This is a very important thing. Not only to apply the administrative law, on water or on construction or whatever, and not only the criminal code, but always they have to have in mind the Constitution. By the way, also for the reason, what happens now, this lady, what happens if an ordinary judge comes to the conclusion the law I have to apply is unconstitutional? What is an ordinary criminal judge? What happens? Speak up. You have the freedom of expression. The lady here? Yeah. If a criminal judge comes to the conclusion that the law he has to apply in a given case is unconstitutional, what can he do? Or she?
He or they need to apply a constitutional complaint. So.
No, not a constitutional complaint, but it's the right. You are thinking the right direction. He has to refer to the Constitutional Court. It's up to the Constitutional Court to check the law, if it is in line or not. This is important remedy or important way how to have the laws to be applied by the ordinary courts checked. So it's not the court itself which can say, oh, I do not want to apply this law because it's constitutional. It's always the Constitutional Court. But in this sense, it has to apply the Constitution because whenever the court applies ordinary law, it has to review if the law is in line with the Constitution. And as we have still, we may say, a relatively recent constitution, there might be still legislation which is not in line with the Constitution. And specifically, now coming back to what we had, the question, your approachment towards the European Union, and trying to come in line with the standards developed in the European Union, also via the comparative law, perhaps you have to come to the conclusion that laws which in former times were considered to be constitutional nowadays are not constitutional anymore under the new interpretation of the Constitution. Okay, Constitution is always important for every judge. It's a very important thing. But the specificity of the individual constitutional complaint, it is that it is the individual, the citizen can bring this constitutional complaint. It does not depend on the judge. The judge may make, must make even a referral if he or she thinks the law is unconstitutional, whereas the individual has the possibility to bring this thing. Again, coming back to my original question, is it necessary to have a specific individual constitutional complaint, as every judge is obliged to apply the constitution? You could say, no, it is not necessary to have an extra remedy for the individuals. We introduced it in Germany to give a weapon in the hand of the citizen, to the citizen, that he himself, she herself can defend his rights. This is a very important thing. They do not depend on the court anymore.
Is it not a myth of the Federal Constitutional Court? Because one of the myths pertaining to the Federal Constitutional Court, which I love, but the problem is with the constitutional complaint in Germany that a huge amount of them is bound by the office of the Federal Constitutional Court. So it is not so easy to use this procedure.
Good question. I come back to it. I will come back to it. It was a good question. I will treat it, of course. I do not want to what you tell a myth, how you call it. But here we are talking about the principle. You can go before the court. The advantage is that the Constitutional Court is specialized in the defense of fundamental rights. It's something different if you have a criminal court, which in first line, of course, applies the criminal code, or if you have a civil court, which applies the civil code or the commercial code or whatever, and if you have a constitutional court, which exclusively applies the constitution, then there is a much bigger protection. Our constitutional court changed the case law of the civil courts, of the criminal courts, because he emphasized the importance of the constitutional law in the interpretation of the criminal code, of the civil code. This is therefore, I always would say it is worthwhile having an individual constitutional complaint. To what extent, I will explain in a moment. The Constitutional Court, as I told you, has the only source of only for its criteria is the Constitution, nothing more. Not in Germany, not even international law, not even the European Convention on Human Rights. It's not a criteria for the Constitutional Court. This is the difference. It's different in other states. In Austria, for example, the European Convention on Human Rights is ranking on the level of the Constitution. Therefore, the Constitutional Court can apply the European Convention on Human Rights like the Constitution. In Germany, the European Convention on Human Rights is only on the level of an ordinary law. It's not constitutional law. And therefore, the constitutional law does not apply it. But there is a difficult case law to which I might come later, perhaps in our question-answer section. And now, and this is very important, in Ukraine and the same in Poland, you have a constitutional complaint. What can be the subject of a constitutional complaint in Ukraine?
About mobilization law.
Yeah, but what exactly? What is the subject of the
It was in force only after 1 month after signed by our President Zelensky this law.
Yeah, but what is the object? How we will call it?
Okay, like have the mobilization, the implementation of the projects earlier.
The audience doesn't see your presentation.
On what thing the court has to decide in?
Be implemented before it's
our document that speak about constitution.
More exactly, what does the Constitutional Court check in the context of the individual constitutional complaint in Ukraine?
Can I go? Actually, in Constitution, oh, sorry for interrupting. Go ahead.
Just to answer your question, since I noticed that you asked more generally and we answered more particularly like the case.
Yeah.
Checks whether the law or provisions of the law is in accordance with the
Exactly. This was the answer I was expecting. The Constitutional Court checks the law or the provision of the law, and this makes a big difference with Germany. Poland.
Dynamic speech at the scientific. It's huge political stuff. Question about do you know Rammstein? The band?
Yeah.
There is a song that I love. The refrain, they sing weiter installieren.
Okay. So how much time do I have? How much time do I have?
2-3 minutes.
3 minutes? Oh. I thought we made a sort of cooperation. Okay, then I will speed up a bit. In Germany, this is the big difference. There is a subject to the constitution check by the Constitutional Court. Whatever act of the state, the individual acts. There are normative acts. There is even constitutional amendments. Treaties or laws with ratified treaties, statutes with ratified treaties, in court decisions, whatever act can be brought before the Constitutional Court. This makes a very big difference to the situation in Ukraine. This makes a very big difference, and therefore much more cases in Germany than in most other countries. Who can bring an individual constitutional complaint? Whatever person, and not only Germans. You can, if you come to Germany, and let's take the case of the policeman in Germany, you can bring the case against this policeman in the end to the Constitutional Court, being a Ukrainian citizen. Yeah, there's no limitation. Young people, old people, even people before they are born, the question of the protection of the fetus is a long case law in the Constitutional Court. Even persons after when they have died can be protected. The post-mortem protection. So it's a very large amount of protection, with one exception, of course. Legal persons under public law cannot go before the Constitutional Court because the fundamental rights serve in first line the protection of the individual against the state. And persons under public law are considered to be part of the state, and so therefore they cannot refer to constitutional to fundamental rights, with some exceptions like universities, for example, or radio television. They can refer also to constitutional rights. This is also important. You also have public television in Ukraine. And in the German public television, not exclusively, we have also private television, but the public television, like the private television, can go before the Constitutional Court to have protected, for example, the freedom of expression. Or churches, which are persons under public law in Germany, they can go before the Constitutional.
You have to turn to conclusions, okay?
Okay. So we have some 6,000 to 7,000 cases. And more than 95% of these cases before the Constitutional Court are individual constitutional complaints. In Turkey, we have 120,000 cases. So this is how can the Constitutional Court deal with this amount, with this bulk of work? And there we have, so to say, a dual court. We have two sections, and then we have chambers composed of 3 judges. And these 3 judges, they decide on the individual constitutional complaints. And these individual constitutional complaints, as a rule, and as you said, they are rejected. rejected, not because the court is lazy, but as a rule, there is no violation of an individual right, because our courts already very carefully check the constitutionality of their own decisions. Only 3 to 4% are granted. So it's a very tiny majority. At the very end, I would like, still coming back to the European Court of Human Rights, going back to, it is of great importance to have an individual constitutional complaint, because this helps the European Court of Human Rights. You know, it has some 60,000 cases a year. 60,000 cases, and to go to the European Court of Human Rights, you have to exhaust the internal remedies, including the individual constitutional complaint. And therefore, if there is a well-functioning constitutional court, many cases will be decided already on a national level, and it's not necessary to go to Strasbourg. If there is not such a constitutional court, every case will end up in Strasbourg, which is still the case with Ukraine. You know, there's many cases from Ukraine going there, and many are granted because you have an individual constitutional complaint, but very limited. Very limited. And this, therefore, I think once we enter the European system of protection of human rights, it makes sense to have a full-fledged individual constitutional complaint, including the possibility to have individual acts checked by the Constitutional Court. Thank you.
Thank you. I have to return to my seat, I'm afraid. Okay, thank you very much. It was very interesting and well, interactive. So our time is unfortunately limited. So with one piece of information for you, we have decided to postpone our conclusions. Which should be prepared by Christina, but am I right? So conclusions after the Kasia's talk, but we are not going to discuss, but I will not be present tomorrow. So unfortunately, because of other commitments, so perhaps we will allow some questions, and at the end, I will collect 2 or 3, and perhaps will be the chance to address these questions, because I'm afraid I'm not be present. I'm not going to be present tomorrow. So our last speaker will be Dr. Habilitated Dr. Professor Katarzyna Kubuj. She's a director of the Center for the Polish and French Legal Thought at the Institute of Law Studies at the Polish Academy of Sciences. And her presentation is entitled Debates and Dilemmas about the Future of the Polish Constitutional Tribunal. Katarzyna, the floor is yours. I don't know whether... yes.
Thank you very much. Can you hear me? Yes, can you hear me?
No, we can hear you.
Oh,
now we hear you.
Can you hear me now? Can you hear me? Can you hear me now? Yes?
Yeah.
Okay, thank you. Thank you very much. And first of all, I would like to thank Monica and Christina for inviting me to participate in this research project. And it's a really big honor to be here. And I very much regret that I cannot be in Krakow today. So I very much regret that I cannot be in Krakow today. And my presentation is the last one to date, so I decided to focus on the some general remarks. Let me start with some important dates, and then I will share this general remarks with you. Poland was one of the first Central European countries which decided to establish a constitutional court. For basic periods of the Polish Constitutional Tribunal may be distinguished the first period, 1986, 1989, the creation and activity of the Constitutional Tribunal under the communist rule, when the court managed to build some authority. And the second period from 1990 till 1997 coincided with the period of fundamental changes in the political system of the country. As the result of these changes, the original model of the Constitutional Tribunal was also modified. The third period from 1997 to 2015, and it was only under the new constitution and the new Constitutional Tribunal Act when the tribunal in its organization and jurisdiction followed the classic Kelsenian pattern. And the fourth period, the Constitutional Tribunal crisis. Initially, this conflict was focused on the composition of the Constitutional Tribunal. Finally, the dispute over the composition, procedure, and organization of the Constitutional Tribunal ended with the majority taking control of the tribunal, but it also led to a reduction in the number of cases decided by this court. The different changes of the Constitutional Tribunal has provoked strong criticism, not only at the national level, but also at the European level. This resulted in the legitimization of this key institution in a democratic state of law. At the same time, the tribunal ceased to fulfill the constitutional law ascribed to it, losing the political and social trust necessary to ensure the effectiveness of its jurisprudence. This resulted in a permanent disconnection of the Constitutional Court with both the legal practice and society itself. For several years, in fact, since the beginning of the constitutional crisis, debates have been taking place of the methods of removing the effects of its crisis and repairing the constitutional judiciary. To suggest a few debates and legislative proposals animated by the Battery Foundation, the Helsinki Foundation for Human Rights, the Jagiellonian University centers, and the publications in the pages of prestigious law journals. Specific proposals for appropriate solution were formulated, indicating the advantages and disadvantages of the various alternatives. Concrete draft laws and even constitutional amendments have been submitted. And the process of reforming the Constitutional Tribunal involves three main tasks: to restore the proper staffing of the Constitutional Court, to sanction the effects of decision-taking in breach of the law, primarily those made in the wrong composition, and to design an optimal legal basis for the tribunal's operation in view of its constitutional function and contemporary challenges. It is not possible to analyze detailed proposal in a short speech. It seems to me crucial in the debate to draw attention to a more fundamental issue, namely the desired shape of a revived judicial control of constitutionality of law in Poland. For without the restoration of instruments of effective and legitimate control of constitutionality of the law, it is difficult to speak of a full and lasting restoration of the rule of law. This, in turn, requires comprehensive changes, not limited to a punctual repair of what has been broken, but the formulation of an answer to the systemic weaknesses of the Polish constitutional practice. I agree with the assertion that work on the future of the Constitutional Tribunal must include a solid review of the experience of the constitutional crisis, above all an understanding of its causes. No crisis appears suddenly, but it is the result of a series of independent elements that were symbolically defined as a crisis. The results of a recent systemic analysis of the literature on the constitutional crisis in Poland indicate that most researchers see the direct cause of the crisis in the intentional action of the political majority formed after 2015. However, among the structural, deeper conditions that make up the crisis, the most common are the weakness of the legal culture, both professional and social, economic condition, primarily the negative impact of neoliberal economic policy, political conditions, primarily the strong political polarization and the questioning by some political circles of the legitimacy of the system based on the 1997 constitution, and the model of systemic transformation and its unfinished nature in some areas of social life, or finally, normative institutional conditions relating to the legal foundations and the operation of constitutional institutions. Depositing the process of appointing constitutional judges in the hands of the simple political majority, effectively excluding civil society from the process, facilitated the political takeover of the Constitutional Tribunal, which became a tool of the political winning majority. However, as one member of the discussion notes, simplistic conclusions should not be drawn from this painful experience. Guaranteeing the real independence of the Constitutional Tribunal cannot be done without the participation of politicians, as it requires building a broad consensus on the systemic role, composition, and basis of the court. The Constitutional Court will only be able to effectively perform its function as an independent arbiter of constitutional disputes if its competence is recognized by a broad spectrum of political forces. Removing the sphere of judicial review of constitutionality from the influence of the current majority does not mean eliminating the political factor in building its legitimacy. The existence of an independent constitutional court must simply pay off for the political elite. As it seems, this was the basis for the position of the Constitutional Tribunal in the first years of systemic transformation. The thesis that the strong position of the tribunal in the first years of the transformation was a consequence of an agreement between the post-Solidarity and post-communist forces. This would argue in favor of leaving the decisive role in the nomination process to Parliament and focusing attention on procedural solutions that enhance the merits of the candidates, the degree of public confidence in them, and in particular, the inclusion of so-called social factor in the judicial selection process. The draft of the bill submitted to the Sejm seems to respond to these expectations. Indeed, the key to rebuilding the constitutional judiciary is to regain social legitimacy. The public must understand the sense of the mission of the tribunal and, even more importantly, experience the positive impact of its action on the protection of individual rights and freedoms in the state. The idea here is to provide constitutional institutions with a permanent, ongoing, and feedback relationship with the public, a relationship that would ensure that the public is able to communicate with the Constitutional Court and that the court is able to recognize the public's understanding of constitutional principles. The process of nominating constitutional judges, as well as the proceedings before the tribunal itself, should guarantee the multiplicity of perspectives of taking about the Constitution, and for example, through instruments of civil society participation in both procedures. For this to happen, it cannot be an institution enclosed in an ivory tower, based solely on the knowledge of even the most eminent lawyers. It must be a modern, efficient office, equipped with an expert base, providing the court with a broad knowledge of the practical social dimension of the constitutional problems under scrutiny. Some of the proposed changes can be implemented within the framework of the existing constitutional regulations. However, more daring solutions will require amending the Constitution. Constitutional re-establishment of the Constitutional Tribunal, although it may seem an unlikely solution today, is in fact the optimal solution. It seems that an important element in the design of the form of the revived control of the constitutionality of laws will also be a rethinking of the role of the courts in the implementation of this task, which until now has been covered by the monopoly of the Constitutional Tribunal. It will also be necessary to create a mechanism to deepen the internal communication of the courts in resolving cases with a constitutional dimension. To conclude, I would like to emphasize 2 points that are important in my eyes. Firstly, the need to answer the question of whether the reforms are to move in the direction of a complete re-centralization of the control of the constitutionality of law. However, in response to a more active role of the courts in this process, a systemic expansion of their competences. Secondly, the need to rebuild the social legitimacy of the Constitutional Tribunal by building public awareness of the importance and functioning of this institution, strengthening educational activities. It seems that from the perspective of the average citizen, the Constitutional Tribunal is the institution whose absence may be least felt. This is a huge challenge for the authorities, lawyers, journalists, and all other entities influencing public awareness in the broadest sense. For the fundamental problem lies in knowing the answer to the question of why the Constitutional Court is one of the key elements of a democratic state of law. Thank you very much.
Thank you, Katarzyna, very much. And as we mentioned, let's have a short Q&A session. I do apologize, I will not be able to come tomorrow, but I have lots of commitments before my short annual leave and before a longer business trip. So tomorrow will be my last day at work. So sorry about this. So let's have a Q&A session. I will collect 2 or 3 questions, and then our distinguished speakers will have a chance to take the floor. Maciej.
I have a question to Professor Katarzyna. Yeah? So I have a question to Professor Katarzyna Kubój pertaining to the problem of the majority by which the constitutional judges in Poland should be elected. Do I understand? Did I understand you properly that you are in favor of a qualified majority? Because at the moment we have only absolute majority, which is very easy to for the current government to elect judges from which will fulfill their expectations. And I'm also in favor of the qualified majority, for example, 3/5. But the problem is that on the other hand, we have to put some security mechanisms. As far as I know, in Germany, for example, in the Federal Constitutional Tribunal statute, there is written that if there is no majority, qualified majority in Bundestag, the current judge will adjudicate longer than his period of office.
But it doesn't happen when he resigns.
Yeah.
Or dies or something like
Yeah,
that.
of course. But if not,
otherwise, yes.
Yeah. So there is a need to organize some security mechanisms if we decide for qualified majority. And what's your opinion on that topic? Thank you.
Okay, so perhaps one more question.
There are 3 questions online. So...
Okay. So, Luisa, perhaps.
Yes, I have a question for Professor Hartwig regarding the
We cannot hear you at the moment.
Can you hear me now?
Okay.
Thank you. So I have a question to Professor Hartwig regarding the constitutional complaint. As we figured out during our conversation, in Ukraine, we have such type of constitutional complaint when we only can challenge the constitutionality of laws or its provisions. Can you think of any remedy for not overburdening the constitutional court with constitutional complaint that has the ability to challenge, that gives people the ability to challenge not only laws, but the application of laws by ordinary courts and other acts of governmental institution. So yes, that is my question. How to know or not overburden constitutional court with constitutional complaints? Thank you.
Thank you. And Piotr.
Thank you very much. Can you hear me? Can you hear me? Could you confirm?
Yeah, yes, we can.
Okay, thank you very much. So I have one question to Dr. Nazari Stecek. You mentioned that there are 3 basic problems with applying foreign law in by constitutional courts, and quite rightly you call them cherry picking, window dressing, and copyright integrity. I entirely agree with that. And my question is, could you select a single judgment of the Ukrainian Constitutional Court that can be considered as lacking of all these faults? So a kind of standard judgment with a real deep comparative analysis. The root of my question is that this is the topic of my research is analyzing applying foreign law by Polish Constitutional Court, and I can find no such judgments without cherry picking, window dressing, and so on and so on. Thank you very much.
Thank you. And the 3rd person is raising a hand, but I don't see the name or surname. So please, iPhone, yes.
So it's probably me, I'm Zuzanna Topulo, and I have a theoretical question about some kind of conceptual analysis from a comparative perspective, which was discussed at the beginning of the panel. I am simply wondering if local court applies foreign law, is it still considered foreign law? For example, if a Ukrainian court applies German law, is it still German law, or does it become Ukrainian law based on German principles, or does it become something shared? I wouldn't call it universal law, but perhaps something broader, just local law. And additionally, where are the boundaries between this German law and the Ukrainian one in this case? And I also have one question to Professor Kubuy. In your opinion, should judicial reforms in countries with a history of crisis prioritize addressing present issues, or should they focus more on gradual inclusion through education and social change. Thank you very much.
Thank you. So now I'm going to give the floor to our speakers.
I couldn't hear the beginning of the question for me. The beginning of this question.
Could you repeat, please?
Yes.
Yeah, of course. Should judicial reforms in countries with the past, like the past of crisis, address the present, what is happening now, or should they focus more like on the wider perspective, on gradual changes?
Thank you. So let's keep the order as in the program. So Olena, the floor is yours. If you want to take the floor.
Unfortunately, due to problems with electricity, Olena must
I see.
break the conference.
It's a pity. Okay, so Nazari.
Question to you, Professor.
Okay.
Answering your question, Piotr, it's a good question. Actually, the short answer is that there is no actually, I did not see such perfect ideal decisions from the perspective of involving comparative materials in the constitutional justice in Ukraine. But the trend is that our constitutional court, besides involvement or applying European Court of Human Rights case law, recently it involves comparative materials. And the function is that these materials are not decisive in any proceeding, but it just strengthening motivation, reasoning, argumentation of the decision. And what is most interesting is that the author of these decisions is the Justice Victor Horodovenko, and he is member of the network of justices of European Network of Justices. And I think it's because his participation and collaboration in this dialogue among justices, and the main reason why it's last current trend. And actually, if answering your question, not only regarding constitutional justice of Ukraine, I think we cannot avoid selectivity at all if we involve foreign materials, because if not to be selective, it means to cite everything, you know. And as a decision or judgment of constitutional court cannot be comparative guide of comparative law. The only thing is that I noticed good practice is when it is some kind of generalization or summarization of constitutional court, and when it position relate to some positions. Yeah, and thank you for good question. Thank you.
Thank you, so Matthias.
Yes, thank you. Indeed, many such complaints are handed in. This is unavoidable. The question is how to handle it. And there are different approaches. The Supreme Court, where you also have a sort of constitutional complaint, has this so-called assertoriary procedure, meaning that the justices are completely free to choose which case they will decide. And they don't have to justify it. Because we will take this case and that case, and there's no justification for it. And so they can limit the case load by their own discretion. This is they are not in this sense accountable to nobody. Germany, they said no. Now we have this achievement of the individual constitutional complaint. We will grant access to the court to everybody. And this is the same approach by the European Court of Human Rights, which in a way copied then the German procedure. How does the German court deals with deal with these questions? As I tried to explain to you, there are these chambers composed of 3 judges. We have in all 6 chambers And we have 6,000 cases a year, so each chamber has to decide 1,000 cases. Many of these cases are of a very lower importance, because if there is a car crash and a witness is not heard, then this is a violation of fair trial. This is a constitutional right. The case can end up before the Constitutional Court. These are easy cases. This makes some 60%, like at the European Court of Human Rights. Article 6 is the provision which is most applied. There are relatively easy, and there are two possibilities. Most are rejected because there is no specific violation of a constitutional right. And the other possibility, if there is a violation, then there is thousands of cases already decided by the Constitutional Court, and that does copy paste in a way. This is when they grant the case. This is how it is done at the Constitutional Court in Germany, and more or less the same in Strasbourg. This is the only way how to deal with this amount of work. Otherwise, if you have a oral pleading, for example, in Germany, there's almost never an oral pleading. It's oral session. The court per year, with these 6,000 cases, there are perhaps 3-4 oral sessions. All other is written. In Italy, each case is oral. This takes time. Doesn't make sense. I worked at the Constitutional Court in Italy. You know, you go in and you don't understand anything, even if you're a constitutional lawyer. They just call up the case and some comments, etc. Everything is confusing, and then the next case. In morning, 10 cases in this style. This doesn't make sense, I would say. I think the German way is better, to have less oral proceedings. The complainant cannot insist on an oral pleading. This is normally always done in written. And then if the case is rejected, there's no need for motivation. This is very often frustrating. The guy who exhausted all remedies, going up to the Supreme Court for years, investing lots of money, in the end he gets the case is rejected according to Article 93A, full stop. This is not satisfying. Therefore, there's lots of space for criticism. No, I do not want to say this is the best we can have. This is a problem. But I cannot imagine to have this very broad approach on the one hand, and then to write decision for 10 pages in each case. This is practically not possible.
Thank you, Matthias. So, so now Katarzyna, as our last speaker.
Thank you very much. And the question of Maciej Pach, I would like to say I agree. I'm for qualified majority. For example, 3/5 to election or appointment of the judge, and the other methods to avoid the situation of this discontinuation, of the disorganization of the activities of the tribunal. It can be the solution, as Maciej said, in German case, and the continuation of the current judge. I don't against for this mechanism, but it's there are the details, and we can talk about the details. I don't go to these details. And for the other question about the experience of our constitutional crisis, I think that it is very important to resolve this situation with the gradual activities and even education activities, and to show how we can work with this example of constitutional crisis, and show to other countries how we can resolve the situation. But it's I don't know if I don't understand exactly the question, but
thank you, Katarzyna, very much. So I would like to thank you, of course, for the discussion, and I would like to thank our panelists, our guests, and because we are delayed, our time is limited, I'm going to give the floor to Christina and Monica. Thank you very much.
Thank you. Thank you very much, dear participants and dear speakers. First of all, it was a great pleasure. Thank you very much for sharing your experience, your knowledge. It's very important for both countries. And I think that the discussion that we had today demonstrates that the topic is really very important. And I think that this project helped to only to start to initiate this discussion, and we will continue our research, and we try to unite all possible communities, I mean scientific communities, legal practitioners, yeah, and to develop some kind of recommendation. And of course, this recommendation we will present, I mean written recommendation, written report, we'll present on our official website, as well as maybe in articles as well. So just because we unfortunately have no time, I would like to thank again the Foundation for Polish Science for supporting our project and for giving us such opportunity. It is really very important for us. We have common problems, and I think that our countries will succeed in the future. I hope for this, yeah, and it takes time, of course, time and energy. And I would like to say that tomorrow we will have also student conference where our students from Yaroslav Mudry National University and Jagiellon University present their joint research, and it was a historical meeting for our students. And so you're very welcome to our tomorrow continuation of this conference. And yeah, thank you very much again, and see you tomorrow. Goodbye.
And we would like you